Please, your lordship. My lords, I beg to mention item number 4, my lords. And for the respondent number 7, my lord, consent from the other side has been obtained.
In fact, on last occasion,
May I submit one thing, madam?
we raised a query regarding the maintainability
My
of the
lord.
petition itself.
My lord.
So now you are seeking adjournment in the last date.
My lords, we would like to file one affidavit questioning the maintainability itself, my lord. Affidavit is ready, my lord. Only thing, my
Where is
lord,
the need of affidavit? You argue it out. It is maintainable or not.
my lord.
Madam, may I submit one thing? In this case, madam, I am appealing for the respondents. This same person has filed 6 PILs, madam. In the realm of, madam, either service law or tender law. Madam, arraying most of the employees of the Assam Agriculture University, whereas he has no connection with the university, madam. 6 PILs he has filed, 2 are listed today, madam.
Seems then he is a vigilant person.
Well, he claims to be a general secretary of a Hindu Satra Parishad, madam. He has no business whatsoever with the university, madam.
That any person can raise a issue of a public importance. But let us see, we have already raised a query regarding the maintainability of the petition on the last occasion, and he has to satisfy that.
My lord. My only prayer that, madam, if my lord is adjourning the matter, let the other 4 PILs be listed along with my lord. He has filed 6 PILs, my lord. Identical.
Deal with this.
This at the request of the London concept of the petitioner. Is this petition on 28th?
Along with these 4, my lord. Along with these 4, my lord.
We'll see to it.
20th
On that-
May.
28th May. 20th May.
43 is same,
My
my
lord,
lord.
so
Same,
43 also similar, my lord.
Along with item.
Same
same person. my lord.
Along with item number 43.
Okay.
This
Obliged.
petition number.
Deeply obliged.
These 2 PILs are listed today.
Yes, my lord.
Yes, my lord. 4 are to be listed again.
Yes.
Obliged.
I'm grateful. Lord.
May I please, your lordships? I beg to mention item number 13, my lord. In this case, my lord, appellant is not inclined to press this appeal, my lord, so I may be allowed to withdraw.
Not inclined to press this petition.
Yes.
Item number 13.
Okay.
Okay, then the council for the appellant has submitted on instruction has submitted the appellant does not want to press this. Let the appeal dismiss this. Not pressed.
Highest is disputed.
Yes.
May I please, your lordship? Lordship, matrimonial appeal was last listed on 15/6/23. Due to paucity of time, the matter could not be heard. I appear for the respondent wife. The order of the family court is in her favor. A husband has been directed to take her back to a matrimonial home. So there is some urgency in the matter. I pray that
Mention before the bench which is having roster.
Matrimonial appeal DB2.
May it please your lordship. Lordship, I beg to mention item number 24, lordship. I'm for the respondent, lordship. This matter may adjourn for a week, lordship. Lordship,
Adjourn.
obliged.
Lordship, in item number 35.
Yeah.
There was an order of this court of 10/5/2023, Lordship, where it was decided that once the writ petition pending for a single judge is heard, after that, this appeal will be taken up, your Lordship. Lordship, I pray the matter may be adjourned for 6 weeks,
Still it is pending.
Lordship.
Adjourn 6 weeks.
Lordship, in item number 44, Lordship, I have filed an affidavit in reply, Lordship. That may be called for.
May it please, my lord. Well, I pray for listing of a matter, my lord. In fact, the matter was, my lord, we paid for listing it on Monday and it was allowed to be listed today. But somehow, my lord, the matter is not listed. There's some urgency. Can it come up on my Friday, my lord? They're supposed to come up today, my lord.
Monday.
嗯
Monday.
Wait, your lordship. Lordship, I beg to mention for listing of a writ appeal. Lordship, the writ appeal was last listed on the month of November 2023. The matter pertains to recruitment of teachers in secondary education. Lordship may be pleased to list it on any date
June 2nd,
subject to your
June 2nd.
like.
For orders, item 1 and 2.
Well, in item number 1, my lord, the amount has already been released to the victims, my lord.
What about this petitioner?
But as regards the item number 2, my lord, my lord, we are filing the affidavit today. I have already served the copy to them, my lord.
That's right. On the last occasion, we directed you to respond why the interim compensation be not granted to the petitioner.
But kindly, my lord, we have filed the affidavit today. Kindly take it up with the along with the affidavit, my lord.
In this first, item number 1.
Now, in item number 1, it is show moto PI, my lord. In show moto PI, my lord, we have the amount has already been released, my lord. I have handed over the document, my lord.
PIL show moto number 3/2022. I'm considered appearing for the state. Senior government advocate Assam has submitted that the compensation to the 6% whose house were demolished, whose houses were demolished, have already been paid by the superintendent of police on 20th of May 2024. He has produced a copy of the letter dated 20th of May 2024, which reads as under.
But
Which reads as under.
well, just there, my lord, one person is left, my lord, because the person could not give. 6 we have given, 1 left because the person could not give the next of kin certificate. We have stated that the next of kin certificate is she will produce us the certificate, accordingly amount will be given.
No, where is that?
But 6 has been given. I'm just
This is for the demolition of house.
demolition of house, my lord.
You have already shown the bank account number and.
Yes, yes. To these 6% we have already given. One more is there.
One more is there.
One more is there. But that person is not in a position to give us the next of kin certificate. It is as per the procedure, my lord. The moment the certificate is given, that will be processed, my lord.
Petition.
Reads as under. Mr. Dinath has further submitted that.
But I have the instructions to
One
that
more
effect.
person whose house has been demolished is also liable for compensation, but due to some procedural requirement, the compensation could not be paid. And as soon as the procedure is completed, he would also be paid the compensation. Full stop. It is only for this purpose, this suo motu BIL was.
But there is another purpose that because an undertaking was given before this honorable court, that my lord, action will be taken against the erring officers, my lord,
That
who without any authority and order, my lord, demolish the house. This is the public
But-
money, my lord, they are
that-
distributing.
For
I'm
that,
sorry.
for that, my lord, at the first instance, my lord, we have released the amount, my lord. It is also under process, my lord. But the authority has sought for some time, my lord. Lord, you may give us 3 weeks time on that, my lord. We'll come up
For
with.
taking, for informing this court, what action has been taken
Yes,
against the erring
yes,
officer.
that will
Mr.
come up, my lord.
Dina
That will come up.
has prayed for 4 weeks' time to inform this court regarding the action taken against the erring officers who were responsible for demolition, for demolition of the houses of the affected persons illegally. Full stop. Time prayed for is granted. Now, PIL number 239.
Lodge.
वो लिखा है ना 6% which reads as follows. Mr. Devanth has further submitted that kin of the kin of the other person who died. Kin of other person late Shafiqul Rahman. Shafiqul Islam, son of late Hamid Ali, are also entitled for compensation, but a formal compensation proposal can be prepared. क्या लिखा है वापिस बताना? Next of kin of other person, late Safiqul Islam versus son of late Hamid Ali, are also entitled for compensation, but since the next of kin certificate has not been submitted till date, the same will be released to them soon. The same is produced. Full stop. Then next, Mr. Dinath has further submitted that in respect of the action taken against the hearing officers who were liable for illegal demolition of houses of the persons, he needs some time to complete his instructions. Time plate for is granted. Now in this second petition,
But
My friend did it.
Safiqul Islam is the victim in the second case, Malad.
Yeah.
This petitioner is the wife of Safiqul Islam.
yes,
So there, Malad, we have filed the affidavit on behalf of the respondent number 2 and 3 today. I have already handed over the copy. I pray that matter may be taken along with the affidavit.
in that petition number 239, इसका heading ये देख करके लिखूंगा, learned counsel.
There's a humble
Mr.
submission.
Dinath
Your Lord.
has submitted that, yes,
In my petition, Annexure 3 is the FIR where the petitioner goes after getting the news of her husband's death. She went to the Ahumgaon outpost under Dhing post police station to file an FIR. The same was not registered. She was sent to Dhing police station. The Dhing police station also did not register the FIR. Again, she was sent to Botodaba police station. And Botodaba police station also did not register the FIR. And same is has not yet been registered till date. And the petitioner is the only independent witness in this case, Your Lordship. Only independent witness. Before her husband was beaten and he died. That is the case, Your Lordship.
but now the inquiry has already been conducted and the hearing officers were found that they are responsible for custodial death. Then what remains in that FIR?
It's it's a humble submission, Your Lordship.
But
It's,
since the inquiry has already been concluded and the
But-
persons were
but-
identified who were responsible
How
for
far they will-
custodial death,
the petitioner being the only independent witness, how far they will incorporate her in this case?
That's not.
So this
That
FIR
we-
may be,
that we will see, but at least for the sake of this, whatever action they are taking, let them come with the response, then we'll consider.
obliged.
Okay, in that petition number 2392, Mr. Dinath has submitted that affidavit on behalf of the respondent number 3,
3 and 4, Malad.
3 and 4 is already been filed. Mr. So and so for the petitioner is in receipt of, you are in receipt of the
Yes, I have
affidavit filed on behalf, counter affidavit filed on behalf of the respondent number 3 and 4. He placed some time to file counter to the same. List after 4 weeks along with so and so.
Malad.
ये same दोनों की date same.
Can't, প্রথম লাইনে যে paid লিখা আছে, paid compensation.
Obliged, Malad.
Item number 3.
Please, Your Lordship. Lordship, in this matter, the process for the pension of the appellant as revenue solicitor has been initiated, but the pension has not been released to the appellant yet, Lordship.
All the relevant documents is submitted to the AG Lordship. AG has to now read answer. Yeah.
He is not even getting provisional pension.
Lordship, that I have to take instruction.
I think she is receiving provisional lordship.
This is of 13/5/2020.
Provisional lordship.
Allowed to submit. Allowed to. Service will basically a permission matter. We will need
So now, what's the problem now?
Because part-time promoting will our name also not shown. And the copy also is not with me. That's now here according to information only I been.
You are for the
I'll take
accountant,
instruction on this point, Miller.
you are for the accountant general.
That is why I'm appealing, Miller. Though my name is not shown. And no
Then
copy is also it is.
what's the problem in that?
That now I.
You know, we are asking concept of the state.
Yeah.
Lordship, we have.
I have to go there and I have to take instruction from them.
Just a minute, yes.
First, I have to. That's what he have given me.
In fact,
I'll go
this
through.
government of Assam, the district commissioner, Nagaon has written a letter to the senior accounts officer, accountant general Assam to requested to allow to submit the rectification of the pension proposal, revenue under your kind consideration. This is in, so whether you are in receipt of that proposal or not.
Lord, today my difficulty is because today that's the only I'm appearing as AG shown. Party, we are not being shown our party. Moreover, I do not
Mrs.
have brief
Arpara,
also present.
Mrs. Arpara, concern
That is why.
for the state has submitted that. They have already written a letter to the senior accounts officer, Office of Accountant General Assam on 13/5/2024, requesting them to allow to submit the rectification of pension proposal of Srimati Krishna Dev, retired revenue Srishtidar. Full stop. Counsel appearing for the Accountant General Assam prays some time to complete his instructions whether the request made by the government of Assam is exceeded till date or not. Is this matter?
डॉक्यूमेंट चाहिए फिर देर और क्या परमिशन चाहिए इसके लिए
29th June, 29th May. Complete your instructions.
show the name of Mr. C. Woodward.
29 June, reflecting the name of.
Only, please, my lord, I'm sorry to say, the 20, I'll be out of business on that day by. That is the maybe.
Which date? Which date?
After just 29th, we'll give second,
30th,
30th, yes.
30th of June.
Madam. Yeah, that would be the best.
कॉमन परमिशन मांग रहा है पेपर ये तो है
Item 5.
No fresh steps in respect of respondent number 7. Yes, sir. despite granting time, steps have not been taken for service of notice upon the respondent number 7. It appears that on the last date, also none has appeared on behalf of the petitioner, and today also no one is appearing. Last opportunity of 2 weeks is granted to take steps for service of notice upon the respondent number 7. On taking such steps, let notices be issued to the respondent number 7, returnable 4 weeks thereafter.
Item 6.
Service upon the respondent number 1 is not
Only on 26 we have taken steps, so service report may be awaited, Lordship.
await return of notice of respondent number 1 for 4 more weeks.
Item 7.
Lordship, only one prayer, Lordship. The name of Mr. R. Mazumdar may be deleted. He is not appearing. That may not be reflected in the cause list.
4 weeks after deleting the name of the R. Mazumdar from the cause list.
Obliged.
Yeah, without reflecting the name of Mr. R. Mazumdar as counsel for the respondent from the cause list. Obliged.
But in this contempt petition, on behalf of the respondent number 1, Malad, we have filed the affidavit.
Yes,
Malad, I pray, Malad, that I'm led by the learned AG, Malad. I pray that this may be taken up to Malad in his presence, Malad.
you have already submitted the proposal for that.
Affidavit we have filed. Affidavit we have filed.
May I please, your Lordship? My Lord, yes, the affidavit is more of a proposal that either if we land is handed over, the petitioner won't be able to do any development work on it. And alternately, they say they have assessed it at rupees 78 lakhs per katha. So I have explained it to the petitioner, so he has opted for the compensation part. So my submission, Lordship, is let them file a detailed affidavit explaining what is the total quantum of compensation that the
Total quantum of compensation, you are aware how much land is there, 78 per katha, then 78 lakhs per katha. What calculation now you needed?
No, as per the records, Lordship, the petitioner was the owner of 1 katha, 10 lesas of land. That is what is stated in the judgments also.
Sir,
So my submission, Lordship, if they file a detailed affidavit explaining the total compensation that the
total compensation, they have clarified that 78 lakhs per katha.
yes,
Then you calculated yourself.
at least my submission is, Lordship, if it is placed before this honorable court.
See, it is there.
Yeah.
Where is that proposal?
Proposal is not there, Lordship. They have stated it in the affidavit.
What they have stated?
Para 4, Malad, sorry, para 4, kindly the relevant portion is at page 4. It is serial page is 27, Malad.
27, yes.
Page 27.
As regard the statement in paragraph 8, this,
No, Malad. Serial, running page 27, Malad.
running page 27, yes.
Logic. The affidavit filed by the respondent number 1. Malad, we have stated that further it may also be stated that the general valuation of the land is 78 lakhs per katha. And if the petitioner is agreeable to accept the valuation of the land as compensation for the land, he would be paid the same in lieu of the land. Malad, the direction of the honorable court is to hand over the land, and this is the alternative thing we have proposed.
Respondent number 1,
Malad, Sumit Sasavar, Malad.
yes.
The paragraph 4, Malad, it starts at page 25, serial internal page 2, Malad. Kindly come to the last portion of the paragraph at page
In
27.
this regard, it is submitted that the state authority is willing to
Yes,
raise
sir.
compensation
Yes.
of land adequately compensating the petitioner rate under the existing law in force. Further, it may be stated that general valuation of the land is 78 per katha, and if the petitioner is agreeable to accept the valuation of land, compensation would be paid to remain in lieu of the land. Now, what remains? What explanation, further explanation you need?
Lordship, how much is the total compensation for the land that they have?
How much
At least
land is, how much land belongs to you?
that as per the record, Lordship, it's 1 katha 10 lesas. So at least my prayer is,
Then
Lordship,
it
if
is very clear. Where is the need of a further calculation?
so if that is placed on record, my lord, they are
So
also.
they have, on affidavit, they're saying valuation of the land, if he would be paid the same in the lieu of the land,
Lordship.
what remains?
Yeah, that is there, of course, Lordship. One per attendance लिखा है उनका one per attendance लिखा है and then 78 lakh per attendance. 10 lakh is आपका 78 plus 78 के half के दिन 78 plus 30. Mr. Sharma, the affidavit mentions 1/10 letters. And then the amount is 78 lakhs. What more do you want?
Yes, yes, sir.
You are reducing us to an executing bailiff. Huh? If that is their stand, if your client is acceptable, we'll close the matter. Is he willing to pay the compensation at that rate? That's the end of the matter.
Yes.
We'll quote the paragraph 2. ये 4 में लिखा है sir. Physically land and on physical land instead of land area of 1 kilometer. Para 4 में. Everything is mentioned in para 4 after inspection. My lord.
Well, may I pray well, that the order may be passed in presence of my senior, well, kindly be taken up at 2. Well.
So what else order we are
That's-
passing,
that's-
the same order we are passing in presence, in your presence, the same order will be passed in the presence
Look.
of learned AG.
I leave it to you.
You won't have to pay. Don't worry.
Okay, pursuant to the direction given by this court on 13/5, this contempt petition is filed by the petitioner. Being agreed with complaining that the order dated 17/11/2022,
Yes, 17/11/22.
17/11/2022, passed by this court in writ appeal number 304/2021, has not been complied with by the respondent. The operative portion of the order dated 17/11/2022 reads as under. This page number 22 say, it is during the
21.
page number 20. see there. This pencil to pencil mark it, na? Full stop. On 13/5/2024, learned AG has submitted that the state is ready to either comply with the direction given by this court or to compensate the matter with a reasonable amount.
Compensate the petition.
Compensation to the petitioner with a reasonable amount. Full stop. He was directed to place on record the offer given by the state government to the petitioner. Full stop. Pursuant to the same, an affidavit is filed on behalf of the respondent number 1 on 18th May 2024, wherein it is stated that the state is ready to pay compensation to the petitioner. The relevant paras of the said affidavit are reproduced here under. This para number 4. Para number 4 be reproduced. Sir. Para 4. Full stop. Learned counsel for the petitioner has submitted that he has already instructed by the petitioner to accept the said proposal. Stop.
Payment of compensation.
But to accept the proposal of payment of compensation. Full stop. In view of the above, no further order is required to be passed in this contempt petition. However, the respondent state shall pay the compensation to the petitioner in terms of the affidavit filed on behalf of the respondent number 1 on 18/5/2024 within a period of
Lordship, give us 3 months time, my lord.
3 months,
But ultimately the
within a period of 60 days from today. With these observations, this contempt petition is disposed of.
Item number 8.
May I please?
Yes,
My lord, this matter, my lord, we have challenged the order passed by the learned administrative tribunal.
yes.
My lord, the learned tribunal has, my lord, allowed HRA benefits to the respondents here in, my lord, who were applicants before the CAT, Central Administrative Tribunal. My lord, at a class B class city rate. Not our contention is that, my lord, the state of
What
Mizoram,
about the notices?
my lord,
What about the notices upon the this?
my lord, we have served the copies to
To whom?
the council, my lord.
Which council? Where is your affidavit?
नाम क्या बोलिए? Paper publication. Okay. My lord, in the affidavit, my lord, the service is complete insofar as, my lord, the state of Mizoram is concerned. It is on affidavit.
You said that this respondent by substitute method. Ramit counsel has submitted that he has filed affidavit regarding service of notice upon the
My lord, in the affidavit which I have filed, my lord, regarding service of notice at page 365.
on 10th of April 2024.
Yes, yes, my lord. My lord, at page 365, my lord, I have given the details of the service. My lord, we have done paper publication in the state of Mizoram. So, my lord, in respect of 129 numbers of petitioners, the service would be deemed to complete, my lord. And so far as other petitioners are concerned, my lord, they are from different state. Page 365, my lord, I have given a tabulation.
This name of the judges and all.
There's the number there.
This you got this notice served. In fact, in the name of the judges. It's
No.
page 398. In the heading, you take notice of the above writ petition, there is that.
Who has issued this notice, Justice?
My lord,
Justice so and so.
no, my lord.
Then who?
You have
They commit to some.
You have to take fresh steps.
Well, in this matter, actually, not some counsel is appearing, not already we have served the copies.
whatever it may be, how you can issue notice in the newspaper in the name of the judges.
My lord,
398. The copy of the paper publication.
yes, my lord, it is by mistake, my lord, I think. I'll correct this one by.
Correct, take fresh steps.
My lord.
You have to take fresh steps. Take care. Pursuant to the direction given by this court on 22nd of December 2023, the petitioners has got a notice published in the daily newspaper of Aizawl city. Full stop. From the perusal of the notice, from the perusal of the copy of the notice published in the newspaper, it appears that the same has been published in the name of the honorable judges who have passed the order dated 22nd of December 2020. This practice of publishing a notice in the newspaper in the name of the judges cannot be appreciated. Full stop. In such circumstances, we are of the view that the service of notice upon the respondents through publication cannot be treated as a proper service. Full stop. The appellants are directed to remain cautious in future in getting the notices published in the newspaper in the name of the judges. Full stop. In the name of the honorable judges of this court. Stop.
Not proper fresh.
Then it consent for the appellant is directed to take fresh steps for service of notice upon the respondent through paper publication in proper manner. Place this petition after 6 weeks.
No. Lord, may I pray, my lord, one thing, Lord, and this connected matter, my lord, the contempt petition is filed in.
We can discuss this petition only on this
No.
ground also. We have simply warned you, that's all.
No.
Item number 9.
We have taken steps upon the,
When
well,
you are appearing for
PhD department, Lordship.
PhD department,
Lordship.
how many respondents are there of PhD department?
all the respondents are from PhD department.
So you are appearing for all the respondents?
All respondents.
Okay. Mr. So and so put in appearance on behalf of all the respondents. Service is therefore complete. List this writ appeal for admission. When?
After 2 weeks,
4
madam.
weeks.
Item 10.
Neither register post with AD has been issued to notice issued to the respondent, number 5. When it was issued? 19/4. You have taken the fresh steps,
Yes, my lord, I have taken a fresh step on
but still the
24th.
notices have not been served.
Yes, my lord.
Still the notices upon the respondent number 5 has not been served.
Yes, my lord, there is no service report. In terms of order.
Await return of notice of respondent number 5 for 2 more weeks.
Obliged, my lord.
My lord, interim order may be continued, my lord.
Interim order, if any, to continue till next date.
Obligement.
Item 11.
Well, in the appeal, we have taken steps, but the service is not complete. Lordship may allow us to take a fresh steps in the matter on the respondent number 1.
As per the office report, notice of service of notice upon the respondent number 1 is not affected since long. Then the concept of the appellant is directed to take fresh steps for service of notice upon the respondent by registered post. By registered post with AD within a period of 1 week.
One.
Just after 4 weeks.
Item 12.
Step has already taken on by the registered post upon respondent 3 and 4, my lord.
You are appearing?
Respondent number 2, APSC.
And what about 3 and 4?
Await service report is
Await return of notices of respondent number 3 and 4 for 3 more weeks.
obliged.
Item 14.
Yes.
As far as we have filed affidavit yesterday.
Right.
Yesterday we have filed also. And copies also I have come to the clerk.
The order is of 2015.
My lord.
Division bench order is of 2015.
And you approached this court only in 2024.
No, my lord, what happened in this case? The division bench held that the managing committee acted without jurisdiction to have disciplinary action against me. So against that, both the parties, I also went to Supreme Court and they also went to Supreme Court because there was a direction for de novo inquiry. So I went to Supreme Court. Supreme Court also upheld the division bench order, my lord. But in the Supreme Court, for the first time, they said that they have already conducted an inquiry in 2019. Some report is there. The Honorable Supreme Court said, then you complete the inquiry. Pursuant to that, my lord, they have passed the order right now, my lord, on 7th of October 2023. And director is saying that it is her opinion that managing committee was correct.
What's correct?
Managing committee that they dismissed me, managing committee was correct, my lord. That is the order, my lord. I am saying that is contempt, my lord.
So how it is a contempt?
My lord, division bench held clearly that managing committee had no jurisdiction. Director is the appropriate authority. So de novo inquiry should be held by director.
Fine.
Supreme Court also said the same thing. Now the order, lordship, kindly see, the director is saying that no, managing committee was correct. But can director?
You can very well challenge this order by way of separate proceedings. But how is the contempt?
That was,
My lord,
put to,
can
was put to silence, lordship.
Yes.
That was put to silence in the petition, it is pending, lordship.
It is
I
pending.
put to challenge because that is regarding my pensionary dues. There my contention is that from the date of my retirement till 2023, there was no advance order. They should pay me pension.
Yes, where is the order of the division bench?
Division bench order is, my lord, page 16. Relevant 16, my lord, 16.
Page 20.
Now read the operative portion.
My lord, the page 19, para 12, my lord.
Yes. Yes.
In that view of the matter, we hold that the governing body had no right to hold inquiry into the matter and pass order of dismissal. Later on, send it to the so approval, my lord. Then, my lord, paragraph 15.
Yes.
It may be that the governing body of a college has been empowered to exercise all power over the appointing authority as per usual norms. The said procedural part cannot be interpreted to mean that the governing body can appoint a person under section 20. The governing body can only recommend to the director for appointment. The said rule cannot be interpreted to mean that the governing body independently can appoint a person under section 6. When the governing body does not enjoy the power of appointment, it has no power to hold inquiry and the power of dismissal. In that view of the matter, director of higher education directed to hold a de novo inquiry, my lord.
Fine.
my lord.
The question of raise does not arise. I think the age of it is necessary mentioned. that
Within
the
6 months,
dismissal of
it was directed,
will
madam.
be entitled, only monetary benefits, so and so. So that's right. But where is the, now this order dated 7th of October 2023, page 1931.
Page 31, my lord.
Yeah, read.
My lord, I'm reading the relevant part, my lord.
Yes.
33. My lord. Accordingly, third paragraph, my lord.
Yeah.
Accordingly, the inquiry officer has submitted necessary inquiry report dated so and so, as whereas as per Rule 2062 of the Assam Services Pension Rule so and so, resignation from public service or dismissal or removal from misconduct, insolvency, inefficiency, not due to age or failure to pass a prescribed examination entails forfeiture of past service. This is not relevant, my lord. Hence, as the case is, there is no scope for reinstating the incumbent as per Honorable High Court order, it is so and so, and dismissal order has already been passed as per the governing body resolution number so and so, as governing body is authorized to determine the discipline and conduct of the teaching and non-teaching staff of the college as per Rule 21 of the so and so rule. As the period of dismissal and suspension falls under the transit period between Assam College Employees Provincialization Act so and so and the rule framed thereunder under so and so, namely so and so. After careful examination of the inquiry report and the record documents submitted, including the show cause reply of the petitioner, see so and so, I am of the considered opinion that the Anjan Kumar Bhattacharya was dismissed from service in accordance with the provisions of law, my lord.
Then where is the violation? Where is the?
My lord, violation. My lord,
What is the willful disobedience of the order of the court, sir? Yes, they may have arrived at a wrong decision, but that can't be.
My lord, I have understood the point, my lord. My only submission, lordship may consider, my lord. This is not an illegal order that I have to challenge this, my lord. I am saying, my lord.
You have already filed a petition challenging.
Petition that is for my pensionary benefit. I say, my lord, that I was terminated in 2008. My due date was retirement was 2009. Till 2023, this is my dismissal order again, my lord. In between, there was no adverse order against me. Therefore, I am entitled for pension. So that is the writ petition pending there, my lord.
So
here I am saying, my lord, how the director can say, my lord, division bench was incorrect and
no, director has not
that way, my lord,
many words that the division bench was not correct, but he took a erroneous decision or wrong decision, whatever it may be. But then certainly it's not a case of contempt, sir. They may have taken a wrong decision, but that doesn't mean that it's contempt. You can challenge the validity of that decision.
Well, then in that case, my lord, my submission is that any decision of the court.
Otherwise, also, my lord, may kindly peruse page 24 of the petition copy, lordship. These are observations on Honorable Apex Court, lordship. Page 24, lordship.
24.
Page 24, lordship.
Yes.
Lordship, last paragraph, lordship, 1, lordship. The appeal has become infraction in view of the compliance of the impending judgment order having been made by the respondent state and the inquiry having been conducted.
Yes.
That was accepted by the Honorable Apex Court also. Lord.
Yes. Honorable Court said, Apex Court said that you have already conducted an inquiry pursuant to division bench order. So your appeal is infractual. It is correct, my lord. Now, my only submission, my lord, my submission only, my lord, if the authority is permitted to say, this court is wrong, my lord.
Certainly you can challenge that, but not a case of contempt, sir. Strictly speaking, it is not a contempt.
Absolutely. Now, pursuant to the order of the court, they passed some illegal order terminating me. That is unchallenged. But here
they have not passed any order. They have said that the termination, your termination was valid
by the managing committee, my lord.
Challenge it. Challenge it.
No, where is the expression managing committee? Director only says, after going through the inquiry report and other records, he finds that the termination of the petitioner is dismissal from services in accordance with the provisions of law. Where does it say that the managing committee was correct?
This dismissal was done by the managing committee.
That we don't find any case.
I leave it to your lordship.
This contempt petition is filed by the petitioner alleging that the appellants, that the contemners have willfully.
contempt.
Single only. The contender has willfully disobeyed the order passed by this court in writ appeal number 273/2011 dated 4/2/2015. Full stop. We have gone through the order dated 4/2/2015 passed by a coordinate bench of this court in writ appeal number 273/2011. As well as as well as the sticky market. As well as the order dated 7/10/2023 passed by the sole contender. Full stop. Having gone through both the orders, we don't find we don't find that the petitioner has been able to make out a case for willful disobedience on the part of the sole respondent. Hence, no case for contempt is made out. However, if the petitioner is aggrieved by the order dated 17/10/2023, 7/10/2023 passed by the sole contender, he can very well challenge the same in appropriate proceedings. Full stop. With these observations, his contempt petition is disposed of, notes is discharged.
Item 15.
So this is an appeal prepared by the state, my lord. While
You are not
preparing the
taking
appeal,
any steps.
yes,
You are appealing.
yes, my lord.
I am respondent one, madam. Respondent two is appearing.
How many respondents are there?
Two, my lord.
Two, madam.
Both of,
Yes, my lord, they have appeared, my lord.
okay, Mr. So put in appearance on behalf of the respondent number one, Mr. So put in appearance on behalf of the respondent number two, and service is complete. Please this. How many delay? How many days delay?
617 days, my lord.
Yeah, what do you want to say?
I have filed objection, madam.
You have filed objection.
My lord. On 6/6/5/24, I have filed objection, madam.
What was the ground taken
My lord, paragraph 4, my lord.
for?
4, 5 and 6, my lord.
Read.
On receipt of this honorable court's order dated 14/7/2021 passed in application number so and so, the matter of provincialization of service in respect of the opposite party number one, respondent number one was referred to the government by later dated 19/8/2021 for issuing necessary instruction as the Assam Transfer Educational Institution Provincialization of Services Act 2011 has been declared ultra vires by this honorable court. Accordingly, the government has instructed by later dated so and so that the matter was referred to the judicial department for its view. Thereafter, the Director of Secondary Education, by later dated 21/11/2022, again requested the government to issue necessary instruction with regard to the compliance of order dated 14/7/2021 passed in so and so, stating that 3 posts of graduate teacher arts were created allotted by the government by the order dated 25/7/2013. However, only 2 posts were filled up by way of provincialization, and 1 graduate teacher arts post is still lying vacant. Thereafter, the government in the school education department requested the learned senior standing council for legal opinion in the matter. After receipt of the legal opinion from the learned senior standing council on 16/10/2023, wherein the learned standing council advised to file appeal assailing the order date so and so. So thereafter, we have preferred this appeal, madam.
Just show us that was referred to the government on 19/8/2021.
Yes, madam.
And for almost good 6 months,
After 11 months, madam.
11 months, you sitting, you have not taken any action. Accordingly, the government has instructed by letter 1/6/2020, 19/8/2021 to 1/6/2022. Government took around 10 months or 9 months
Yes, madam.
in giving its opinion, and thereafter, again, 21/11/2022, the secondary education has
Director
again
can
requested the government necessary instruction. And that letter was taken care of only on 16/10/2022. 16/10/2023.
23.
And 10/23, the government has directed you to file an appeal, and appeal is filed in February 2024. There is not an explanation. We are not going to accept that.
But here only,
This posting is still vacant.
only difficulty in our part,
Now,
act has been declared ultra vires by this honorable court.
whatever it may be,
But now we
we are
cannot,
we are not on merits. We are on this delay.
is that,
you're
that
not-
I, that I understand, but that I understand.
So you have not explained the delay at all. No explanation.
There is, in fact, there is some delay on our part while,
Some-
yes,
Some
implementing.
delay.
Though they have taken some steps, but
Sorry, sir.
only difficulty in our part, since the act is no longer is existing.
Whatever it may be,
No-
whatever the difficulty, we are not going into the merits so far as delay part is concerned. That was declared as ultra virus way back,
Yes, my lord.
not on 19/8/2021 or in between this.
No, my lord, it was declared in 16, my lord.
Then you are aware of this fact. You are sitting, nothing like, we care. This, Mr. So-and-so put in appearance on behalf of the respondent number 1 and Mr. So-and-so is appearing on behalf of the respondent number 2. Full stop. This IA is filed on behalf of the state with the prayer to condone the delay of 6 months, 7 days in filing the present.
617 days.
617 days. 617 days in filing the connected appeal. Full stop. It is stated in the affidavit that the judgment dated, impugned judgment dated for the copy of the impugned judgment dated 14/7/2021. It is stated in the affidavit that after receipt of the copy of the order dated, impugned order dated 14/7/2021, the matter was referred to the government wide letter dated 19/8/2021 for issuing necessary instructions. Full stop. The government thereafter wide letter dated 1/6/2022 as instructed that the matter be referred to the judicial department for its view. Full stop. The delay caused in between 19/8/2021 to 1/6/2022 has not at all been explained by the applicants. Full stop. Further, it is mentioned in the affidavit that again the Director of Secondary Education wide letter dated 21/11/2022 requested the government to issue necessary instruction, and the government has thereafter responded the government in the school and thereafter the government in the school education department requested learned senior counsel, senior standing counsel for legal opinion in the matter. Full stop. It is noticed that the period running from 21/11/2022 to the date when the opinion was sought from the learned standing counsel has not been explained. Full stop. It is further noticed that even after the receiving of the legal opinion of the senior standing counsel on 16/10/2023, this appeal is preferred only in month of 2024, and the said delay has also not been explained. In such circumstances, we are of the view that the appellant has failed to satisfactorily explain the delay in filing the connected appeal. Hence, no case for condonation of delay of 617 days is made out. The application IA number so and so is therefore dismissed. Resultantly, the writ appeal number 1523/2024 filing number बाद में लिख देना इसमें regular is also dismissed.
Obligation.
Item 16.
Wait, please, your lordship. This is an application praying for condonation of delay of 265 days.
265 days.
Well, the grounds are are placed before this honorable court in paragraphs 8 and 9. Well, what had happened? This honorable court had directed on 14/6/23 in the honorable single judge's order that his representation dated 3/4/23 be considered by the GB. Now, what he does, he sends it to Calcutta. The trust operates out of Calcutta. The school is in Balipara, Assam. He sends it to Calcutta. That is the reason the chairman of the appellant number 1 before this honorable court did not receive it. And the delay was occasioned. He
Copy of the
contempt application on 1/3/24, my lord. That's when, my lord, the appeal also thereafter came to be filed before this honorable court.
Where is the order of the learned single judge?
Well, it's pages 150 to 52 of the accompanying appeal, my lord. The operative part is spelled out in paragraph 7, my lord.
My lord, what I am saying, they are not come with a clean hand before this honorable.
File any objection?
Yes, your lordship, on 17/5.
17/5.
Yes, your lordship.
But it is not available on record.
My lord can fix a date.
The concept of the respondent has submitted that he has already filed counter to the IA. However, the same is not available on record. Office is directed to place the same on record and listed on 30th of June.
31st, my lord. 30th, I have some problem.
31st of May.
Yes, your lord.
31st of May.
Item 17.
May it please, my lord.
Yes.
My lord, this is a substantial issue which is now pending before 3 high courts, my lord. Before my lords, before Calcutta High Court and also before Delhi High Court. The issue is which of the 2 pensions are to be paid.
You mean to say that in identical appeal involving
In similar,
the same issue pending is
yes,
pending?
before different high courts.
Here also pending?
This is the matter, my lord.
This is the matter. It is not pending. Still, delay is to be condoned.
My lord, may I explain why delay would not be material here? Because nobody's rights are being prejudiced by this delay at all.
Why?
What has happened is that the single judge has ordered that the widow whose writ petition was disposed of, she should either be paid pension under EPF Act or under the CCS pension rules. And that finding is incorrect. So EPF organization has come up in appeal.
Either paid, what do you mean by either paid?
Malad,
There's
what had
no
happened?
direction of payment of this pension in a particular that EPS or general pension.
May I explain what has happened, Malad? There was this individual who was in service of the Airport Authority of India for the better part of his life. Whenever he got his wages at the end of that month, he contributed a part of those wages towards his pension under the EPF Act. So he himself was investing and funding for his future pension from his own salary. Parallelly, the Central Civil Services pension rules came up with a commitment that the government would fund a certain amount towards people's pension. So the 2 pensions are being funded independently. One, the employee himself, the other, the government. The government is not funding the second pension. But when this matter is considered before the learned single judge, the direction comes that only if the widow forgoes her pension under the EPF Act will she be entitled to the pension under the CCS pension rules. And that's fundamentally incorrect. These are 2 different statutes, 2 different frameworks.
Notice of the application, returnable on so and so, registered AD.
My lord, may I also make a request? My lord is issuing notice on the application.
Only application.
My lord, this appeal needs to be considered. It's a serious issue because the act has been rendered.
First of all, the appeal be registered and that can only be done after registration of the appeal.
The only reason I made this request is this. We are saying that let the widow have both the pensions. We aren't asking anybody for anything.
Let them other part.
Obliged, mother, obliged.
Yes.
Item 18.
Grateful.
May it please your lordship.
Yes, you are appearing for?
My lord.
You are appearing for?
National Highway Authority of India, my lord.
So what happened? You have shifted that toll gate.
Disregard, I have to take instruction because this part, Lordship may grant some time to take instruction on this
The
point.
simple is that
Yes, my lord, I
uh,
understand.
you have filed an affidavit that will
Yes,
adjust it.
yes, by 31st
At a
January.
place which is not
23.
crowded, whether you have adjusted it or not.
Let's say, my lord, what action has been taken, I have to take instruction, my lord.
What you are complaining?
Yes, regarding adjustment lordship, that is all to comply the order in.
Adjustment
Yeah.
means, what do you mean
From
by,
the-
whether
from
they
the
have
crowded,
adjusted
because-
or they have this established that toll gate on the very same location?
They can after 5 meters away, lordship, and from the crowded area, they can shift the place.
Shift the place, whether they have shifted or
No,
not.
not yet. That is why we
Whether
have
they have
come up.
established that toll plaza here or not.
No, here already established lordship.
Already established. Toll plaza. So you mean to say that they have not adjusted till date?
Yes, lordship.
So how this revival of the PL file a contempt?
Lordship, we have filed a contempt, lordship. Lordship may peruse page page 23, lordship.
Yes, what happened in that?
In that case, lordship, may I read the contempt? So and so hard, so and so.
NHA, Mr. in the PIL. Commissioner.
So I was advised to file a
So this is
revival of the,
contempt. We mean to say that contempt.
yeah.
If they have not complied with their undertaking, file a contempt. Why this revival of PIL?
Because already we filed that and direction was given, advice was given that we should file a revival petition first, thereafter lordship. That is why this petition being filed.
There is a specific direction. We close the PIL with the direction to the respondent authorities, more particularly the respondent who the needful for adjusting the Midnapur in terms of the affidavit filed on so and so away from the current education institutions. This is a clear direction. File a contempt. Why do go for this revival? File a contempt.
Lordship, we will.
This application is filed by the applicant.
Contempt already closed.
Essentially with a prayer to
Lordship,
revive
yeah.
PIL number.
Okay.
79/2020, which was disposed of by this court on 1/6/2022 with a specific direction to the respondent authorities, more particularly the respondent number 5, more particularly the chairman NHAI Northeast region to do the needful for adjusting the Madanpur toll plaza of Baihata Charali in terms of affidavit filed on 30th of May 2022 away from the crowded areas and educational institutions. In this application, it is claimed that the said direction of this court has not been complied with. Full stop. We are of the view that if the direction given by this court is not complied with, the proper course for the petitioner is to approach this court by filing appropriate application for disobedience of the order passed by this court. And this court, hence, we deem it, we are of the view that no case for revival of the PIL number 79/2023 is made out. 2020 is made out. The application is disposed of.
Lordship, so for the contempt, page 28 will also be taken into consideration. We have
So far as
page 28, Lordship. We have
28, what is this 28?
that is what, Lordship, we have filed contempt petition before filing this revival petition.
What happened in that?
That advice was given that we should file and
Who advised
accordingly, Lordship, that honorable court, and then only we
You
saw.
filed and withdrawal, you have withdrawn for that, you have withdrawn that contempt petition.
So this may also be kindly observed, otherwise there'll be future inconvenience in filing, Lordship.
Line of that. Withdrawal, it will be open. You have to seek review of this.
If you will be.
You
Review can go.
to make contempt to it, which was told you, can I do it? Legally, what legally?
So, the matter comes for consideration of the IEA, wherein a prayer is made for revival of the PIL number 79/2020, which was disposed of on 1/6/2022, while granting liberty to the petitioners of the state petition to pray for revival of the PIL if necessary remedial action is not taken by the respondents. Stop. Mr. So-and-so appearing for the NHAI, prays some time to complete his instructions. Complete your instructions.
My lord.
This one, so and so.
Deeply obliged.
Item 19.
Ma'am, Lordship.
Yes, fresh.
Lordship,
It is fresh.
regarding IA Lordship, yeah, convention.
It is listed for the first time.
Yes, Lordship.
Issue notice of the application under section of the IA number so and so, returnable on so and so.
Yes, my Lordship.
Item 20.
Yes,
Lordship, may it please, it's my lord. 60 days delay in preferring the
63 days.
60, I'm sorry, 63 days.
Just
For
one
for
minute.
the first time. In 60, yes, you are appearing. Yes, Madam. I am appearing for 1 and 2, my lord. 1 and 2? Yes, Madam. How many
Is to
respondents?
condone it.
And 3, 4 and 5.
Governing body 4 and 5, Lordship, there are no set of councils.
Okay, the matter comes upon for consideration of the IE number so and so with a prayer to condone the delay of 63 days in filing the connected appeal. Mr. So and so put in appearance on behalf of the respondent number 1 and 2. Let notices be issued.
And H. Chalia for 3.
And
Mr. Chalia, you are for 3.
and Mr. So and so for respondent number 3, let notices be issued to the respondent number 4.
At 5.
4 and 5 returnable on so and so. Yes,
For admission, item 21 and 22.
May it please your lordship. Would my lord be pleased to take up 22?
22, yeah.
I think the second file. My lord, my name is Khudeja Begum and another lady, Saleha Begum. The entire case is that my services were provincialized. This was challenged by her in WPC 2428 of 16, which lordship is taking up now, on the count that I was overaged and not duly qualified as per the service rules. During the pendency of that proceeding, they could come to know that she was also terminated, challenging the other lady.
Who was terminated?
My lord, Saleha Begum.
Writ petition.
Saleha Begum is a writ petitioner. She filed 2 writ petitions. The first writ petition was filed challenging my provincialization on the count of age and qualification. During the pendency of those proceedings, she would come to know that she was terminated. Now, she said no inquiry, no notice, so she filed the second writ petition. That is also there. Now, at this stage, both the writ petitions were taken up together. The education department, they placed the records. To show that the writ petitioner was never in service. But
Is there any specific observation setting aside the termination of service?
termination was set aside on the count that notice was not given.
Where is the
Where is
finding
that
of
finding?
Lordship.
setting aside of
Page 28, paragraph 27. No, the observation part I'm telling you.
Yes.
Page 33. Para 33, page 31.
This what our would observe the stage of no semblance of any procedure has been followed. Therefore, this court is analyzing opinion termination was cannot therefore set aside. So this appellant, the learned single judge has cancelled the provincialization on the ground that she was overage at the time of entry into the service.
My lordship.
So
We say our appointment to the post was prior to the rules or the act which came into field, and therefore the conditions of age and qualification would not be applicable to me.
when the rules came into force.
2003, we came in 99.
So prior to that, there was no
This requirement was not,
qualification
this
for-
requirement not.
any person even of 60 years can be appointed.
But this was by a resolution that was appointed because the earlier person, the Saleha Begum, had
There
left the
must
job.
be some qualification for appointment, even though in the absence of rules of 2003.
This specifically, it was not there. And this was never objected by anyone to that question. That 40, that age
Then
factor.
they can,
Reasonable.
they were free to appoint a person of 70 years,
No,
80
I would
years,
not say
90
so.
years.
I would not say so.
Then-
Reasonably, that was not there.
What
So I
do
was,
you say
it
reasonably.
was not there. But the question is false, is not.
And they may also appoint any person of 10 years of age,
I
any
would
boy.
not go to that far, But may I just apprise your lordship one thing, The education department had placed the records to show that the writ petitioner was terminated and not in service in 1998, 1999. This was not taken into consideration by the honorable single judge as no affidavit was filed.
That is altogether different.
I
You
understand.
are not aggrieved by her setting aside of her term.
No, I understand.
You have not challenged that, na?
No, we have not done.
You have simply challenged your setting aside of this
And we have maintained that stand that
provincialization.
at the earlier point of time, we are prior to the rules, and therefore stricto sensu, this requirement of high secondary or 18 to 36 would not come in. So we had maintained that stand right or wrong.
There was no such requirement. And can I just say that,
Yes, Mr. Who is appearing for the state? Mr. Majumdar. Was there any requirement of minimum qualification for appointment on the post of teacher prior to 2003?
2003, the venture educational institutions, they used to take in persons who were at that point of time matriculate or higher secondary
Higher secondary?
or matriculates, depending on the class
Without
to which
there
they were being
being any-
appointed.
Without there being any bar regarding age and
Those were private institutions, we did not.
private institutions, but
Not
must
yet.
have followed.
Because
some
the NCT norms, NCT
criteria.
norms and everything. The appointments in the venture educational institutions were not done per se as per the government requirement. They were small schools established by the
He's
community
right in
themselves
saying that there was no qualification for appointment or there is no age bar
as such.
as such. Then what's
For
wrong?
entering government service, there could have been, but for in the venture school, there could have been no bar. Is
The respondent appears to disqualify and prescribed.
the non-government school act also came in 2007.
This para number 35,
Madam,
this learned single judge in the improved judgment, the question which now arises for education is the action of the provincialization of service of the respondent by depriving the petitioner. Admittedly, the respondent number 8 is junior in service to the petitioner and does not possess the requisite qualification of higher secondary. The respondent number 8 also appears to be disqualified. Okay, two grounds, her provincialization was set aside. That requisite qualification, higher secondary was not there and she was overage. Yes, up to
The
that
other-
extent that there was no age prescribed, therefore it can't be treated as overage. But so far as regarding this requisite
secondary part.
qualification of higher secondary,
but the
High
main
secondary
ground which perhaps has been relied upon is Madam, that at that point of time, it was the senior person who would be provincialized. If she is junior to the person not provincialized, Lordship will have the first paragraph. Admittedly, respondent number 8 is junior in service. 2011 it required the senior person to be provincialized. And if the writ petitioner was senior, she had the
and does not
right-
possess the requisite qualification of higher secondary.
that is additional. If first the junior, senior has to be considered.
Higher secondary comes in slightly down the line. the requirement of higher secondary, and I'm sure they will admit to that. This is after the rules come into force. Prior to that,
Prior to that, there was
it's
no,
not there.
it
I
was
stand
not
by it.
prescribed this
Yes,
minimum
yes.
qualification as well as age.
I am educated, but not a high secondary pass. So that way it comes in, because I could serve the job given, and the state is not objecting on that.
Who is senior between you and the private?
She's stood terminated in 1998, is an admitted stand by the state. Therefore, there's no question of seniority, my lord, if I may address it that way.
She was terminated in
1998, August 1998, page 26, paragraph 17, the standard of the official respondents, my lord.
And
After she went, I came in.
and that order of termination has been challenged in 2016.
Absolutely.
And you appointed in the year
99. After she went out, I walked in.
Initial appointment of number.
you entered into the service in the year
1999.
1999. So
My-
you must have attained the age of superannuation till now.
90. No,
Is it about?
no. On the verge.
Only birth. The learned singles is observed that at
41.
that time, in
I
the
have to
year
do- I
1999,
have to
you
do
were
the computation.
41 years of age.
I have to do the computation still. I got the problem. I got it.
What
If
remains?
40.
41 years of age, you were appointed in 41 years of age. And now, what's your age?
I'll get back to you, Lordship. I'll get back. I got it. 99 is 41. Then 24, it cannot be that. So
The affidavit says in 2023, she was 59. The affidavit says to the IA. The appellant was 59 years old when it was
on the verge, I
2023.
said.
You are almost 65 years of age at present.
I have to check on that. It struck me now.
This is what the fact
I
is.
got it. I got it. Whether she denied and disputed the factum of age or being overage, that's the question now.
In fact,
If she thoroughly denies the 41 years, then it's okay. এখন কি যে কোন নিমু পাত্র না এখন উলাই যাব পেছেন এখন কি ধরেন আসি আছে এখন একটা নেক্সট কোন উত্তর
in fact, when this order was passed, you were already attained the age of superannuation. In 2023,
in case 41 is accepted.
this is the finding of the learned single judge.
Absolutely. If 41 is accepted, then yes. But if it is denied, that overage, it totally is denied.
Either you
As a
have,
genus.
now you can make this argument.
I understand.
Either you say her age was not 41 at that time. What is your argument is that there was no minimum prescribed age for that purpose and therefore 41 is also good. This is what your argument, what we understand. So now, what remains in this petition then? Since you have attained the age of
Two things would
superannuation,
remain, my lord. Two things with all respect would remain. The first is the order affects both ways. It says I am gone and she comes in.
so that is, you are not challenged that order.
But two appeals are there.
Two appeals.
Two appeals are there. Two appeals are there.
What is the present age of your client, Mr. Borbuya?
She was also appointed in the year 1998.
Yes.
She must have attained the age of superannuation.
No, Lordship.
98 termination. Your
At
appointment
the
was?
time of filing of the writ petition,
Your appointment was?
You have not mentioned the age in the writ petition.
46 years. as of
46 years on 2016.
46.
Yes, in 2016.
She also must have attained the age of superannuation till now.
No, no.
16 Lordship, 46.
10 years, 8 years.
No,
When was she appointed?
I was appointed in the year 1996 on 28 to 1996.
1996.
96.
And the age in 2016 age was?
Age was 46 years. My date of birth 31/12/1970.
This is back calculation. 46 2016. It will be started from 26. It took only from another angle. Judgment be regard on the. Regard on intimate, but exit not.
And you remain in service till pendency of the writ petition.
Yes.
When you retired,
But
actually,
I must point out one thing. Page 98 is the affidavit filed by the writ appellant. There, 98 of the appeal is the affidavit in opposition filed by the writ appellant. There, as on October 2016, I may be precise, 26th of October 2016, her age is reflected in 52. If it is 52, assuming, my lord, assuming, then this October I walk out.
then you have not
Then we go to
challenged the-
60 in
you
October.
have not challenged the finding of the learned single judge that at the time of your initial appointment, you were 41 years of age.
I understand.
You have not challenged that finding.
Even otherwise, my lord, I take it against me. If I am 52 as on 2016 October, then 24 is 60. I am.
Either you can't make your submissions in this manner that you are not challenging the finding of the learned single judge.
We have
This
challenged the
count-
overage part. Overage part to be said, to say that it is not applicable without the
Mr.
figure.
Constant, either you
Correct.
should make one argument
I get it.
that there was no age prescribed and therefore appointment can't be treated as illegal. Or either you say that on that day you were within age.
No, I say the form.
So you are saying that since there was no age prescribed at the time of your initial appointment and the 2003 rules came thereafter. So this will not affect your appointment.
I would submit so.
You would submit so, then what remains now?
I understand.
Since you have attained the age of superannuation way back in the year 2020 or 21. Now you are almost 65 years of age. Still you want to continue? What else?
I get it. I get the permission for your lordship with him.
What remains in this appeal, I don't understand. Why you are contesting this matter?
No, I was told I was in service.
You
I
already,
check up the. Someone said I was continuing in service. Then we have to check up the record. understand.
as per your instruction, she is still in service.
That's what I should not be more explicit.
When counsel for the appellant is directed to file an affidavit of the appellant that she has not attained the age of superannuation and still is liable to be continued in. service.
If it also mentioned a recorded date of official.
In the said affidavit, the appellant shall also state about a recorded date of birth in the,
Supporting document.
with the supporting documents. Then we'll have to pass an order for recovery of some amount which you have availed after the age of superannuation.
All right.
This one. 30th of, 10th of June.
Item 23.
Well, this is an appeal against the judgment and order passed by the learned single judge, my lord, in a writ petition filed by the second wife claiming pension
Yes, what happened?
for her child, my lord.
Last occasion, you were supposed to decide the claim.
Lordship, as per my instruction, AG has issued letter and required some clarification from the department. Some part of the clarification already been communicated to the department. Later on, Lordship, 14 May 2024, they have intimated the communication whereby they required that portion of the unmarried daughter part shall be approved for the pension and public grievance department, Lordship. So we have already sent the file to the pension department. Lordship, some time may be given.
How much time?
Lordship, 10 days. 10 days, Lordship.
You'll get it sorted out within 10 days.
But hopefully, Lordship. We are trying our best, Lordship.
Mr. Advocate for Accountant General, on the last occasion,
Yes, but.
you were granted some time.
Yes, that is why immediately we have sent letter. What is the criteria required for the settlement? We have sent a letter to get effect letter. Yesterday one clearing one portion, yesterday time. Remaining other portion, my learner submitted that it has sent for PPG department, which is she is waiting. That is the condition. Yeah, as soon as you get it, Miller, within when I can 3 days early. As soon as that will be.
Go off the time. Go off the time. Then present.
My lord, if I may take your lordship to the impugn judgment, page 77. My lord, to settle
We are
that.
aware of your predicament.
My lord, if I may submit on the point of law, my lord. My lord,
Whatever simply the learned single judge has directed them to complete the exercise and assess that who is entitled for what pension is there. We are simply on the last occasion, so we directed them to complete the exercise expediently. Now we are granting some few days time to them to complete this, or otherwise we'll call the officer concerned for that purpose.
well, in my humble submission, the full bench judgment passed in the case of Juniper baby, it's very clear, my lord. No point of law would be required for the department to decide as to who is entitled to get the pension.
Let the learned single judge, once have passed an order, let them comply with, otherwise.
My lord, I agree by the paragraph itself by the single judge, my lord.
If you are not, then we'll admit it and put it on hearing. Place it in a hearing in due course.
Certainly, my lord, but this will deprive the.
Try to understand, we are try to help you. We are not here for that.
But the only predicament is she is 76 years old lady.
So that's why only we are granting them few days time, sir, taking into consideration this fact only. Okay. And Council for the Agriculture Department of Government of Assam has submitted that the pension proposal to the family of the deceased is already proceeded as per the direction given by this court. As per the direction given by the learned single judge in the order dated 23/2024, which is under challenge in this writ appeal. It is submitted that the necessary exercise would be completed within a period of 2 weeks from today by the concerned officials of the Agriculture Department of the Government of Assam and the officials of the Office of the Accountant General in Accountant General Assam. Stop. Taking into consideration the above submission made on behalf of the Government of Assam as well as the Council for the Accountant General Assam, we deem it appropriate to list this writ petition on 11th of June 2024. We make it clear that if the necessary compliance is not made by the next date of hearing, we will be forced to summon the concerned official personally before this court. Do it within 2 weeks, whatever by the next date of hearing, place the order on record.
We have this order.
Earlier.
for this conversation, yes.
Much obliged.
Item 25.
Before I start, I must tender my apology, Vinod. My friend has pointed out that a particular page is not annexed to this appeal. I think I should file an affidavit to place it on record.
Adjourn. The request of you.
Obliged, Lordship.
Obliged.
Item 26.
May I please? My lord, before going to the impugned order, my lord, I want to take a lordship to page 90, my lord.
Before going to the impugned order, directly page 90, okay?
90. Because that is an order, another order in the proceeding, my lord, whereby the Honorable Single Judge has asked for the status report with regard to the FIR against the petitioner, my lord. And that was not placed while, my lord,
Mr. So-and-so, oh, Mr. P. Sekia, I was referring to the affidavit in association filed that the FIR was not against So,
the case of the petitioner was rejected, my lord, on the ground that there is some criminal cases against the petitioner. And that's why the district level committee has rejected the claim of the petitioner. Though there was direction from this honorable court in the earlier round of litigation to consider his case against the court vacancy of the other department. That is not done, my lord.
Director of the, on the issue of certain documents where your claim commissioner, new council has referred element.
But to our submission, my lord, to our,
So what happened?
there is no such registered criminal case against the petitioner. There is no such registered case against the petitioner, my lord. So this honorable court directed for the status report.
Your case was rejected on the ground that
There are some criminal cases against the petitioner.
only on that ground.
Only on their ground, my lord. Not going to the other aspects as per direction of this honorable court.
And the learned single judge has non-suited you.
Honorable Single Judge, my lord, while on the 5/10/2023 directed the state government to place the status of the case. But that is not placed.
Okay, okay, yes, no such FIR is there, that's right.
No such FIR.
Now,
my lord,
your father died in the year.
That, my lord, 2005, my lord.
So,
And this honorable court in the order dated, my lord, order dated, my lord, 5/11/2021, page 71, my lord.
yeah,
As directed, my lord, for placing the case of the petitioner, my lord, for consideration.
in the
Yes.
year 2021.
Yes, Lordship.
And they have
While
rejected.
they are considering the case, my lord, they have not considered as per the clause of the office memorandum, my lord.
For then you approach this court by way of this petition.
Yes, that's it. Read
Wow.
petition.
By claiming what? That the present proceedings by the present non-consideration of appointment commensurating is educational qualification. The petitioner is also also in this connection presented a challenge to decision committee towards rejecting the appointment of the petitioner therein. The father of the petitioner late Shri so and so. You applied for compassionate appointment in the year?
Immediately, my lord, within the time, my lord.
In the year?
2006, my lord.
2006.
Within time.
Within time?
1 year, my lord.
Then what happened to your
Application remain unattended, my lord.
application?
Remain unattended by the.
Anything else?
This is my humble submission and simple case, my lord. I pray for, my lord, a direction for placing the case.
Now, what's your age in the year 2006? What was your age?
But, 18 years, my lord, in the year 2005, my lord.
2005, 18 years.
18 years.
Now, what's your age?
Now, 2005, 18 years, my lord, 15 years, and it will be another 20. Yes.
So now we'll issue a direction for giving appointment to you relate back to 2006. And then all the consequential benefits, including the payment of salary, promotion and everything. At least
That I have not.
this much you deserve, please.
That I am not praying, my lord.
This much you deserve.
I am praying for only for consideration, not for any other direction.
This writ appeal is directed by the petitioner against the order dated 22/4/2024. Passed by the learned single judge in WPC number 4708/2022, whereby the learned single judge has dismissed the writ petition filed by the petitioner seeking compassionate appointment on the ground that the father of the appellant, in place of appellant died in the year 2005, and the petitioner, the appellant and his family members having been able to sustain themselves in the long period after the death of the father of the petitioner, it is not a fit case to direct the respondent authorities to consider the case of the petitioner for appointment, consider the case of the appellant for appointment on compassionate ground. Full stop. While arriving at this conclusion, learned single judge has placed reliance on the decision of the Honorable Supreme Court rendered in State of West Bengal versus Devbrat Tiwari and others reported in 2023 SCC online SC 219. Having heard the learned counsel for the petitioner and after going through the material available on record, we are of the view that the learned single judge, we are of the view that the impugned order passed by the learned single judge is not liable to be interfered in the facts and circumstances of the present case, hence no interference is called. Writ appeal is dismissed.
Right, appellant.
Item 27.
May I please the petition? Matter pertaining to family pension, my lord. Petitioner challenged the impugned order dated 10/1/2024 passed by the learned CAP, my lord, where petitioner claim was rejected on the ground that her name was not enlisted as a nominee in the disease employee service book, my lord. So which this observation is not correct, my lord. He tried to enter, my lord.
My lord, she was the second wife of the deceased employee.
Name of Srimati Nirodha Das is by for the central government as well as the declaration of
The lady was in service.
My lord,
Wife was in service.
husband.
no, my lord.
Husband.
Husband was in.
His husband was in service. His first wife was died on 2005, my lord. After her death, he married to me in 2008 with Hindu rights and restoration. And marriage was registered in.
What is this order in page 52?
She's relying on an order.
Another.
one.
So from where you got this that she died in 2005?
2000, she was died, my lord. First wife was died in 2005.
How to substantiate this fact?
My lord, page number 30, I have entered the death certificate, my lord.
Page number?
30 in my petition.
But in the year 2012, he declared that his wife is alive.
Yes, my lord. Yes,
Then-
he has declared.
Then
My lord, that's why, my lord, Cat rejected me on the ground that, my lord, he had not informed that his wife already died.
Death certificate. 26.
this, where is the death certificate?
My lord, page number 30, first wife death certificate in page number 30.
30.
30, my lord. And Bulbul Das certificate husband's disease employees certificate is page number 26.
Date of death is 17 to 2005. Maybe month and The nomination is about the death of the form will be the authorized person to decide. But that person by nomination does not get the right to appointment. If this lady is dead, the queen will not be able to the nominee. इसको भी मेरा it's a 2019 we did not take. After his death, his legally married wife will be entitled to family pension. Whether or not he nominates. Family pension किसको देगा? वो भी दे तो वो भी दे surviving by these executions of crucial legal matters. Law will come into picture. So nomination does not give right of appropriation. It is only the nominee on record. Who is receiving the family pension now?
The son is disabled son is getting respondent number 4, Lordship.
Son?
Disabled son, Lordship.
Disabled, sir.
Disabled. son.
Disabled son, but he is not.
Respondent number who is respondent number 4, Lordship.
Respondent number 4.
Lordship.
My lord, by submitting false certificate, he is receiving this pension, my lord. He is not physically.
What was your response to this certificate of the death of person?
Lordship, that is obtained in 2017. Moreover, Lordship, in all the declaration form, nowhere stated her name, Lordship. In 2012 also, if she at all died in the year 2005, Lordship, what we have stated by the deceased employee, Lordship.
My lord, he has not mentioned that she has died, my lord.
That your Lordship will find at page 101.
What is the mechanism with the railways to find out? It is only the declaration form which can give the information about.
Because in the group insurance at page 101, Lordship will find, Lordship, then Nirodha Das name is reflected. 101, Lordship.
In 2000.
And in page 102, this declaration is given in the year 2012, Lordship.
Then also.
There also, Lordship. Her name is not there, Lordship.
Actually, he was working as a.
Where is the original of the marriage certificate?
My lord, not. Today I am not.
Marriage certificate, you are not placed on record.
Yes, my lord.
That has been annexed, Lordship.
Page?
My lord, is 29 in my original petition.
Yeah.
It was in 2011, my lord. It was registered by.
ये 2008 का है। Died in 2005.
Notice जाओ बोले पहले respondent ऐसे तो notice जी को पूरा
original produce करे तो प्रारंभिक ले सकते
Respondent number 4 appear होना है क्या? I'm notice दोगे
बात We have the beginning. We have to see special marriage.
What is this annexure, page 27, Government of Assam, this
Hello, this is next up.
27 and Meena Das, Himanta Das,
Hello, this is the next
Ramita
up.
Das and son. Who declared, who issued this?
Office of the Deputy Commissioner, my lord, issued this next of kin certificate, my lord.
And what about his disabled son?
My lord, this is the second, my lord. Second one is Himanta Das is the, now he is 40 years, my lord. He is not disabled child, disabled person, my lord.
Admit, Mr. So-and-so is appearing on behalf of the
1, 2, and 3, Lordship.
1, 2, and 3. Let notice be issued to the respondent number 4, returnable on so-and-so. Disabled son name is
Himanta Das,
Simanta Das.
my lord.
And he is in the skin certificate is,
Second, my lord. Says,
go to Himanta Das. He is Himanta Das, not Simanta Das.
my lord. It was typographical mistake.
Yes. Grammatically. Proper name as. Maybe.
Returnable on so-and-so.
Replayable.
Item 28.
Yes.
May I please? Lordship, Rectification challenging the order passed by the learned debt inquiry tribunal at Quota thereby rejected the prayer of the petitioner for impleadment of the particular as a party respondent in the RPC application.
इस टॉपिक पे मैटर के बारे में आ रहे let's raise to verify in this before.
It's typically tribunal. To implead, they have refused to implead home party.
Lordship, who is a purchaser? Lordship, may I have a brief submission of the fact of the case, Lordship? A petitioner before your Lordship availed a loan of rupees 25 lakhs. On his failure to pay, his account was classified as NP on 31/3/2021. Thereafter, bank issued a letter to him, thereby asked to pay. And also, it is also thereafter again a letter issued, thereby asked him to Lordship submit his assigned policies for accreditation of the account. Accordingly, it was paid, amount was deducted, and Lordship it was upgraded. But bank initiated a proceeding, courtesy proceeding, showing that it was classified as NP on 31/3/2021. That is not correct. Subsequently, it was upgraded, and when again it was classified as NPF, that was not made clear by the respondent bank. Proceeding initiated, and Lordship suddenly in the year 2022 physical possession was taken.
That's right. That are the facts of the case. You approached the DRT and made a prayer for impleadment of whom as
Purchaser, who is the purchased the property lordship,
who purchased the property.
lordship, in the auction proceeding lordship.
Why you want to implement them? Why
you want to implement them?
Lordship, sales certificate, we have challenged the sales certificate lordship.
That is, if he is agreed, he'll come. Why you are making him party?
You can't challenge sales certificate in DRT. Who's the applicant in DRT?
Lordship, borrower lordship. Borrower is the applicant.
You are the purchaser.
No, lordship, I am the borrower. We have prepared the application under 17 of the SARFAESI Act before the DRT. Lordship, somehow purchaser was not made a party respondent in the SARFAESI application. As his proper address was not there, bank furnished it in the month of May. Subsequently, lordship, application was filed for impleading him as a party respondent.
All right, so court has, the DRT has not allowed you proceed. There will be no prejudice to your interest. You proceed.
Your interest is going to be prejudiced. Which is the order of the DRT?
Lordship, that is at page 90.
Yeah. So the DRT has said the purchase of the property neither necessary or proper party.
Lordship.
How is a necessary or proper party as per you?
Lordship, we have challenged the sales certificate. If
Sales
any order
certificate, you
passed
are
by
not
the authority,
You
that
have
will
not
violate.
challenged the sales certificate, sir.
Lordship.
You have not challenged the sales certificate. You have challenged the e-auction notice dated 10/1/2023. You have not challenged the sales certificate in the.
All lordship. Sales certificate, e-auction notice, possession, everything.
Sir, when the sale was completed?
Sale was completed on 28 lordship 2023.
And you have filed this.
It is filed in time. This application.
We are not on time. You have challenged this. The DRT has observed. It is also observed that the applicant has challenged the e-auction sale notice dated 10/1/23 on the ground. Only on the ground that the notices under section 13(2) and 13(4) of the SARFAESI have not been served upon the applicant. Therefore, the respondent bank failed to follow the procedure under the SARFAESI Act. This is what your challenge before the DRT. You have not challenged the sales certificate.
Lordship, may I take your lordship kindly have a look at lordship petition, SARFAESI application lordship before the DRT. That is, I have also annexed.
Yes.
Lordship, that is at page 60, started from page 60.
60, yeah.
Lordship and operative lordship concerned para lordship kindly have a look at page lordship 66. Relief sought for. In view of the fact, as mentioned above, the applicant prays for the following relief, that this tribunal may be pleased to set aside the sale notice dated such and such, newspaper and also e-auction sale notice dated such and such. Cancel the sale certificate dated 28/2/2023.
बोल भी दिया वैसे नहीं उसको क्या पहले नॉन जेंडर और नेसेसरी पार्टी में अपॉर्चुनिटी दिया था फेलियर होने से ट्राइब्यूनल बोल दिया
there is no prejudice to you, even though if he is not.
Otherwise, I have not, but if he challenged again, we may face that's why we have for abundant.
This writ petition is filed by the petitioner, essentially being agreed with the order dated 19/3/2024 passed by the Deputy Tribunal Guwahati in essay number 56 2023, whereby it has dismissed the application filed on behalf of dismissed the IA number 368/2023 and IA number 371/2023 filed by the petitioner with a prayer to implead the auction sale purchaser as party respondent in the proceedings pending before the DRT. Would stop. The learned DRT has observed that the persons sought to be impleaded as party respondent are neither necessary party nor proper party for adjudication of the surface application filed by the petitioner. Having heard the learned counsel for the petitioner and after going through the material available on record, we don't find any illegality in the order passed by the DRT, hence this petition is dismissed.
Applied.
Hence no case for interference is called for, writ petition dismissed.
Item 29.
Who's on the challenge?
Yes.
May I please with your lordship, my lord? My lord, the basic grievance of the petitioner, my lord, is regarding the holding of the post of assistant headmaster in a high school, my lord. My lord, the rules of 2018, that the secondary rules of 2018, my lord, the basic qualification and the criteria, which is a mandatory requirement, my lord, for filling up the post of assistant headmaster is prescribed under Rule 15, my lord.
So these rules are under challenge in the other series also, which were there yesterday.
No, my lord, that is under the Provincialization Act of 2017.
28 of this
My lord,
rules of 2000, it is not under challenge in any other petition.
No, my lord, I don't think so, my lord.
A few specific provisions, my lord, which relate to the qualification given for a vice principal.
Vice
or-
principal, yes.
Those are under challenge.
Those are under challenge. They're listed today also. So few matters. Today's list also
My-
they are there. His challenge is something else, my lord.
My lord,
File your response.
my lord.
I'll file my response, but perhaps to his convenience also, this scheme, which is challenging, has been upheld by the Division Bench of this Honorable Court, and what was the scheme then has simply been incorporated as a rule.
We are not,
You might like to go through it.
This whole scheme is, you mean to say that validity of this service rules 2018 has already been upheld?
But
No.
that particular provision, section 28, rule 28, what he's challenging when we allow a person in an amalgamated school to hold the post of the headmaster without having the B.Ed degree. It was earlier as a scheme, an amalgamation scheme. It had come in prior to 2018, in 2016 came as a scheme. Entire scheme stood the test by Supreme Court. So that
The law only puts the scheme into
the scheme has been incorporated into a rule.
we are not challenging the scheme, my lord. We are
You are
challenging the
not
rules.
challenging the scheme, but
Fine.
what he is saying that earlier what was provided in the scheme
Is just
is
the
now
Is
concluded to a
incorporated
law.
in the rules, my lord.
That scheme was already upheld.
My lord.
I'll find it.
Issue notice, Mr. Majumdar, accept notice on behalf of all the respondents.
My lord.
All the respondents.
Private respondent is also there, my lord. One, two, three,
Having
five.
heard the learned counsel for the petitioner, we deem it appropriate to issue notice to the respondent number 124 only.
1 to 3.
For 1 to
3.
1 to 3 only for the time being.
My lord.
Full stop. Mr. Majumdar accept notices on behalf of the respondent number 123. He may file his counter to the writ petition by the next date of hearing put upon June 2nd week.
My lord.
Obliged.
Obliged.
18th June. 18th.
Item 30.
But one, on the last occasion, there was a direction to the finance department to have inspection. But that part is evaded. Can it be after a week? Next Friday.
Yeah, the judicial department has nothing to do here. Because judicial department who have made a party in the writ petition, they have rejected our claim by filing affidavit. So in that view, they will do nothing further. Earlier also, we had filed representation before the judicial department before filing this writ petition. And there is a correspondence made between High Court registry and the judicial department registry on the record. They have done nothing.
So you have filed this writ appeal against the impugned order whereby the learned single judge has directed the judicial department to consider your prayer and
Yes, my lord, but the judicial department has already rejected our claim by filing affidavit.
when it is rejected.
When it is rejected, huh? It is rejected. Let me check. That is my lord. Page 89, this is the affidavit. Page 89, annexure 6, my lord.
This your prayer was rejected prior to the issuance of prior to passing of the impugned order or after passing of the impugned order?
No, according to them, the petitioner is not entitled to the pay scale recommended by the City Commission. My case is, my lord, the petitioner, she was appointed as a record keeper in the establishment of the presiding officer Industrial Tribunal Silchar in the year 1982, my lord. And since then, he was working there till her retirement in 2022. But the judicial, at that time, the labor court, industrial tribunal, they were under the control of the labor and industry department, my lord. Subsequently, it has come under the control of the High Court, 2010, and the judicial department. So, City Commission recommendation recommended 2 pay scale, one for record keeper and one for record entry, my lord. That is in the page. Action plan. Action plan is one. If you want. Page 53, your lordship, can you see?
Where is the order of rejection by the judicial department?
There is no order of rejection, but in affidavit, they have filed affidavit.
Judicial department filed affidavit and they
The writ appeal,
read petition.
writ petition.
Yes.
But now the learned single judge is.
Yes, lordship is correct.
What happened to that?
My lord, pursuant to the honorable single judge's order, they were required to submit a representation and judicial department to consider.
No.
My lord, whether he submitted or not, my lord, that.
It is already pending there. Before filing the petition, we have filed representation.
Sir,
It is pending there, my lord.
pursuant to the
So
direction
once-
given by
once
this
they-
court, please, sir, listen. Pursuant to the direction or the observation given by the learned single judge, have you filed any representation with the judicial department or not?
Representation file
No, we have not filed it. because
You have not
we
filed
have
any.
Come before your lordship, because they have, when they have rejected our claim by filing affidavit, then what is the use of filing representation before the judicial department? They have already rejected our claim, my lord.
Listen, having heard the land concept for the party, for the appellant, we deem it appropriate to admit this petition, admit, issue notice, Mr. So and so.
I am appearing for, my lord, respondent number 2 and 3, my lord.
How many respondents are there?
4 total.
Who is appearing for the 4?
I am appearing for 4.
Mr. So and so put in appearance on behalf of the respondent number 1, so and so, so and so. Service is therefore complete, no need to issue formal notice. The counsel for the respondents may file their counter affidavit. The counter affidavit lists this matter for hearing in due course.
Right.
Item 21.
Lordship, the appeal by the review, Lordship, the impugn order is page 27, Lordship. Appeal was dismissed on the ground of national litigation policy because the amount is below. But there is an exception to that, Lordship, when the question of law is involved. Here, Lordship, that appellate authority granted interest to the SEC. Under
Procedural, we find that the amount involved in the present case below monetary limit, which 50 lakhs, which has been notified by board instruction related to accordingly the appeal are dismissed under the national litigation law.
But
So-
there is an exception to that also.
What is?
Lordship, if the substantial question of law is involved, then department can file and department irrespective of the
Where is
amount.
that, where is that exception?
Yes, Lordship, because here the issue is involved.
The exception,
He has not, in the impugn order, it has not been written down. Lordship.
where is that exception in the black and white?
Yes, sir.
Where is that policy? Have you placed the policy on record?
It is
That
Lordship.
national litigation policy,
Yes, Lordship.
you have placed it on record.
No, it is not placed on that.
So how can we find that it is a case of exception?
No, Lordship, we have taken ground and this is the policy, Lordship. May kindly carry it, Lordship. This is an instruction of the department, close to, which says that in certain cases, irrespective of value, the department can.
Which is that, which,
Below the value, Lordship, because it is a latest, earlier also the same provision was there. Earlier, the value was less, by this notification, value was less. Lordship, here the question involved is, they were entitled to some exemption under notification 32/1999. And there was.
This is this says it should be contested.
Lordship, yeah, contested. Lordship. Lordship,
It doesn't say anything on the jurisdiction part.
no, Lordship, we can contest, Lordship, because before the tribunal appeal was filed. But without considering the respect to the matter, the tribunal dismissed the appeal on the ground that,
this case of the SSC is covered under which of this eventuality mentioned in para 2 ABC? It covers under which?
Lordship, 2. Lordship, because.
Where the notification, instruction, order or circular has been held illegal or ultra vires.
Lordship,
Where is that?
In this case, what happened, Lordship, there is a notification number 30/1999.
Yeah.
Which speaks about giving exemption to the SSC. That doesn't speak about payment of interest to the SSC. So what happened? This honorable court in one of the writ appeal upheld that section 11B will be applicable in case of.
Sir, whether the SSC or the assessing officer or the authority concerned against which you have approached this CSET,
Lordship.
whether that authority has declared that notification
No,
illegal,
they have stated they are entitled to interest under notification.
that is altogether different thing. Until and unless the notification, instruction, order or circular has been held illegal or ultra vires, you can't contest.
Lordship, but here the question whether we are entitled to pay
So
interest.
that is altogether, if the 50 lakh amount is there,
That is there.
then this question can't be going to.
We said that it falls under the exception. We can, even if.
When which exception is for it falls? Your case falls in under which exception?
Paragraph 2.
To support his contention by these things comes under exception.
And the tribunal make mention of.
Where is the order against which you have approached the CTET?
Lordship,
Which is that order against you have filed
Yes,
this
Lordship.
appeal before the CPAT
Yes, Lordship, this is at page 15,
15.
Lordship.
Where is the operative part?
This is the operative part is at paragraph 16, page 25.
Page 25.
The impugned order is partially modified to the extent that
Just a minute. The ratio squarely applies honorable that these objections that occur by tendency of revenue insurance or for the harassment of the SSC side. So similarly, it is a wrong to false motion entertained by lower order. The revenue must be refunded with the legal due so must be not refunded whether the unhealthy attitude of some so the said refund applicant is also the said refund amount due to the appellant this money has been collected retained unlawfully by the party thus wrong decision. The appellant has not obtained I'm considered to make this same order is partly motivated, but one of the steps that has been Sir, we don't find any.
But see, this in this case, what happened? There is a judgment of division bench of this honorable court in amalgamated, where this honorable court held that if there is even if there is no provision of payment of interest in notification, but section 11BB will be applicable. The matter.
We are not on merit.
No, Lordship.
The matter is admittedly less than 50 lakhs.
Yeah, that is correct, Lordship.
And for the purpose of contesting the matter further, you are required to satisfy that in these three exceptions, in which of the exception the case of the SSC falls. Show us.
There is another instruction which the tribunal make mention. Lordship 2011. I'll produce. Lordship may take up tomorrow. I'll.
Then you should have. Okay. By this appeal, the revenue has challenged the order dated 2/11/2023 passed by the Custom Excise and Service Tax Appellate Tribunal, Kolkata, whereby the excise appeal filed by the revenue was dismissed, recording that the amount involved in the present case is below the monetary limit of rupees 50 lakhs, which has been notified wide board instruction dated 22nd of August 2019. Stop. Learned counsel for the appellant prays some time to satisfy this court that how the appeal, excise appeal preferred by the revenue was liable to be decided on merits by the CTET. List after 3 weeks.
Much obliged.
Item 32.
May it please the Lordship. This PIL is filed by two public activists, including a journalist, to bring the focus on probity in public life and transparency in governance.
By the filed by the
two persons. One is an activist, social activist, and the next is a journalist. They have been pursuing a case of corruption since 17, and the rules are that when a preliminary inquiry is completed by the vigilance, the next phase is the regular inquiry. And from 7/16, they continued with their application to all the authorities, including the central government's CP Graham, and they didn't get any response. In fact, the chief secretary was always kept in the loop. And one of our cases, that our simple case is that there has been an apathy and inaction on the part of the state respondents, which comes within the principles culled out by the Supreme Court. I will show from Supreme Court judgments. The Supreme Court has culled out certain exceptions, and the person who is being complaint was lodged is now occupying the highest post in the PWD department, in the chief engineer.
This is
And-
inquiry, you prayed that the Vigilance Cell and Anti-Corruption Department pursue and complete the investigation
Yes.
in regular inquiry number RE 7812/2017.
Yes.
What is this inquiry is?
This inquiry, we didn't know from 16 we were pursuing. It
Where
was
is that-
only in,
Where is that inquiry? Which
but
document? you are
we came to know, your lordship will come to page 168.
referring?
The chief secretary was kept informed. We got a document,
168.
168
Just-
is the minutes of the selection board's meeting for the respondent to the post of chief engineer.
Just
Annexure Q 168, lordship. If I may read. Minutes of the selection board's meeting for selection of officers for promotion to the rank of chief engineer, PWD from additional chief engineer, held on 28th of January 2004 in the conference hall of the chief secretary. Well, the chief secretary always heads the he is the chairman of the committee. Well, lordship will come to a very vital part at page 169, serial number 11. Can I read, lordship? The selection committee board observed that there is a regular inquiry, which we are now calling upon, your lordship, under progress against Sri Debajit Das, who is at serial number 2 in the zone of consideration Assam, as intimated by the Political Vigilance Cell Department of Assam, but details of the case, alleged charges are not furnished by them, and hence the selection board asks the PWD to obtain details of the RE and to place the same before the selection board's meeting. So the chief secretary was informed, he knew, so he rightly took a decision that today we are not going to take any decision because the regular inquiry part has not been intimated by the vigilance department, and the matter, page 178, 170, the meeting gets postponed, adjourned, sorry. Then on the next day, we pursued our matter because from 16 we came to know that this is still pending and it's in the regular inquiry, because regular inquiry presupposes that earlier preliminary inquiry was complete. Now, what had happened? Suddenly we get an information that on March, 5th of March, this person becomes the chief engineer. Annexure S. So our case is that Supreme Court of Judgment.
Suddenly become a chief engineer means the selection board has selected him.
No, assuming that when we sought for the documents from the RTA, because we were pursuing the matter, and the regular inquiry was not informed to the chief secretary on 24th of January when the meeting was held. The matter got postponed. Chief secretary possibly thought that since complaint was against this person, we are not taking. Because the CVC guidelines says that the eligibility criteria will have to be looked into. Then when we sought for it, we were not given. We came to know that this person was already promoted to the post of chief engineer.
So the selection committee might have in the information that the inquiry was over or something.
That we don't know, only when they, so our,
And how this PIL is?
no, Malad, this PIL is not on, Malad, this
Essentially, you are
PIL, I like to.
challenging the promotion of a particular officer.
No, Malad, this conclusion is on the apathy part, inaction, and the court has very categorically held that apathy, and when the influential persons are involved, the High Court under 226 can play a corrective role. And we are not seeking a registration of the case. We want to know that we have been pursuing this matter. This is the case, you know. Because here what has happened, the Supreme Court was in session of a matter of corruption against the Chief Minister of Sikkim. Supreme Court and the
Simply
statutory.
saying one complaint was there. What is the nature of that complaint?
What
What
are the
type of complaint? Kya tha?
The nature of the complaint was that there was case of
Vigilance Cell
yeah,
Department of Assam
money
for
laundering
details of
and
alleged charges
there
are
was a
not
case of
furnished to them.
disproportionate
The
assets.
selection board asked the PWD. What was the complaint? What was the nature of that complaint?
The complaint-
Sensual, was,
Page 33,
investigating
Lordship.
what?
Page 33, we gave a detailed complaint to the tax department also, and we were called also
So
for our
this
case.
is your complaint?
Yes, madam.
How can it be? How you, this
Madam.
number 7812/2017 was your complaint?
Madam,
It was your complaint?
the regular inquiry was pursuant to our complaint.
Which inquiry regular?
The regular inquiry which finds mention in this election committee's meeting.
78/12/2017.
Yes, Lordship.
Where is that? From where we got it?
Page 169.
From where we'll get this, that this inquiry was initiated on your complaint?
That will be, the respondent will have to show.
You have to show, sir. This may
Well,
be
I did
another
not get
inquiry.
I pursued the matter from 16,
Whatever it may be.
and seeing the factor that there was
Sir,
inaction and
this-
apathy.
This RE number 78/12/2017
Yes,
was registered on your complaint. You have
yes.
to satisfy.
It was registered on our complaint means the fact that,
From where we get this?
that will come only because that's the reason I have
You
approached
can't
it.
simply say that.
No,
we have, filed
no,
a complaint
this
on
is not a
basis
case.
of This case
One-
was registered.
No,
What is that,
this
sir?
is not a roving and a fishing inquiry I am seeking. I am seeking on the limited extent that the inaction of the part of the
Sir,
vigilance.
first of all, you have to satisfy that this, whatever the re 78/12 was initiated on your complaint.
Yes, because I was called on two occasions by the vigilance, the statutory authority and the income tax authority.
What communication you received from the vigilance?
No communication. We were informed that you come and give
By
your
whom?
statement. By the vigilance and the income tax. We have made them a party.
And this very much inquiry is in relation to your complaint?
Yes, Lordship.
From where we got it, sir, please satisfy us.
If we are not in excess of some government documents, if I can show that on my complaint,
Sir, ultimately, you have to satisfy us that your inquiry, on your complaint, some proceedings were initiated and that has not been finalized.
it was on
today,
my
and despite
complaint
that
of
person-
disproportionate asset and corruption that the RE 17 was registered. So only the chief secretary asked about this man.
So ultimately, you have to satisfy us.
We will satisfy
And-
because.
And another question is, sir.
Yes, Lordship.
So now essentially you are against the promotion of that person?
No.
Sir,
I know.
please try to understand what we gather from this, because you have referred to this, that this person, his promotion was put on
Yes,
hold
why? Yes,
on account of some inquiry.
yes, I have an
So
answer.
basically you are aggrieved by that person that he is a corrupt person, he should not be promoted.
No,
to that
I'm not on that. I'm in because I'm in the realm of a larger concept. The third concept of PIL, the transparency and probity in governance. The Supreme Court's
Sir,
three-phase.
that's all together, but first of
I have come on that point. I'm not against his service area. I don't have any case.
then why you have filed a complaint against him?
My lord,
Why you have filed a
I
complaint?
had filed a complaint as a journalist and an activist because I got material.
Journalist and activist, but you just, where is your complaint?
My lord, yes, your lordship will come to page 33. A very detailed
Page
page 33.
32.
33, lordship, annexure A.
Yes,
If I may read the contents.
yes.
Prayer for an inquiry investigation into the corruption of Mr. Devajit Das.
Executive engineer.
Yes, that time that I would like to submit some facts as well as allegation of corruption of one Sri Devajit Das, executive engineer. The brief background, Sri Das in the year 96 as an assistant engineer, and by the year 2003, he could accommodate his posting as OSD to the chief minister. That being an OSD to the CM, Sri Das was able to manage two out of turn illegal promotions filed from 22. He became assistant.
Okay,
And in-
yes. So
Yes,
this,
but I
this
think-
complaint is essentially against this one person, Devajit Das.
Yes. And why I say, Lordship has rightly asked, and I'm going to answer that question.
And
That-
on this complaint,
Yes.
this inquiry, whatever the number you have referred,
Yes,
78, so and
it
so
is.
was initiated.
Yes.
Where is that?
Yes.
From where we got this?
Well, look, that's from knowledge of the minutes of the meeting where we got that.
Sir, this inquiry on your complaint, this inquiry was initiated, you have to satisfy us, sir. And you also explain that these two petitioners have filed this type of complaint against how many officers?
No.
No, sir. If you are a so vigilant person and against the corruption, then it is not the only person who is indulged in corruption. This is
No,
not the
no.
only government officer who
The
is
reason
indulged in
was-
corruption.
There's a reason to it. The fact that he had tremendous influence could be gauged from the fact.
Sir, there are so many persons who have tremendous influence in the administration or where government officials particularly.
Yes.
Have you filed such complaint and those persons are also involved in
Well,
corruption?
when I have
You
filed a-
filed in your this whatever the career as a journalist or as an activist.
Yes.
Against how many persons you have?
Well,
filed a complaint?
my filing against other is of less relevance for the.
No, sir,
simple
it is an important question because if you are such a vigilant person, that time and again you are raising these issues.
No, my lord.
You are not
I'm
raising time
raising
and
issue.
again, then
Why
why
I
you are
was
after
raising
this
the issue?
one person only, sir?
No, why? Because of his influence, my lord, I could show that his career promotion, because I have to
If
relate.
you are an activist or a journalist,
No,
then
my
you
lord.
are supposed to take very issues of public importance.
Yes, for
not in
prohibiting
relation
public
to
life.
only one person, but in relation to several other persons. If you are so much concerned
My
about
lord.
the corruption of a government officers, why are you targeting one person, sir?
Because the Supreme Court, when his matter went up to the Supreme Court, his career, the Supreme Court categorically said that this was a classic case of a fraud indulged by a person, the respondent number 12. And I fear that because of his influence, where he got his out of turn promotion, the Supreme Court gave a categorical finding. Lordship will come to 130.
Supreme Court, where was the occasion for the Supreme Court to give?
No,
this finding?
I was referring to the Supreme Court for the limited purpose, not about his, I'm not concerned about his service career, whether he's become the chief engineer. I say that his influence over the entire system could be gauged, that the Supreme Court in his case only has said that he had committed fraud of the highest order and all his yes, page 132, paragraph 28. Because this matter went up to the Supreme Court. We are of the opinion that it was virtually a case of fraud, at least on 3 counts. First, by creating an ex-cadre post of executive engineer only for the respondent 1 and giving him that
he
post.
approached the Supreme Court against which order?
My lord, what has happened? This person was the OSD to the earlier CM, and he got out of turn promotion over 105 engineers. So naturally, the entire engineering force association came. He came and he was reverted back on the complaint of the association. He came to the High Court, and in the court, the single judge held that it was a case of fraud. Then he went on appeal. Appeal went in his favor, against which the entire association went to the Supreme Court.
After lunch.
Pronouncement of judgment. Item number 1, judgment will be delivered by the Honorable the Chief Justice and bench constitute with Honorable Mr. Justice N. Unnikrishnan Nair.
In view of the above discussion, we have no hesitation in holding that the learned cat has erred in setting aside the charge memo dated 20th of February 2015 issued against the respondent, as the impugned order cannot be sustained and the same is liable to be set aside. In the result, the writ petition allowed the impugned order dated 7/11/2017 passed by the learned cat Guwahati bench in OA number so and so is hereby set aside.
Item number 32 of regular bench will continue.
May please, Lordship. Lordship, I'm taking your Lordship to page 130. 130 of my PIL, paragraph 26.
Yes.
Having regards to the circumstances in which respondent number 1, that is respondent number 12 in my petition, have given promotion to the post of executive engineer by vacating an ex-cadre post, and thereafter the manner in which was encadred to the said post by stretching the number of vacancies against record, speaks volume about the manner in which undue favor was shown to respondent number 1. One has to keep in mind
then at that time he was working as an OSD to the Chief Minister. These facts reflect clear manipulation of the system at various stages to give out-of-turn promotion to respondent number 1 by bestowing undue favor. With such flyover promotion, respondent number 1 parachuted from assistant executive engineer to superintendent engineer by passing many senior colleagues in the cadre of assistant executive engineer who are still stagnating at the same cadre. When this factual position emerged on record and was approved by the division bench as well, we are of the opinion that the writ petition could not be dismissed on the ground of delay and laches. In fact, the division bench has erred in invoking this principle by dubbing the entire exercise as a bona fide error. What happened cannot be termed as bona fide. It was a clear case of favoritism shown to respondent number 1, and the actions were contrary to the rules. Para 27. That apart, there is one more reasons for coming to the conclusion that the division bench of the High Court was in error in saving respondent number 1 on the premise that the writ petition suffered from delay and laches. In fact, the association has submitted a representation to the then Chief Minister. Going by the nature of allegation, the Chief Minister rightly acted upon and referred the matter to a committee which, after examining the matter, has also given its report stating that the promotion of respondent number 1 was against the rules. This provides reasonable explanation for delay, if any. We are of the opinion that it was virtually a case of fraud, at least on 3 counts. First, by creating an ex-cadre post of executive engineer only for the respondent number 1, giving him that post when he was much junior to many colleagues, others. Second, encadrement of the respondent number 1 as executive engineer by showing that there were 13 posts, which in fact were only 10 posts of executive engineer on that date. This was done obviously with the purpose of accommodating him. Third, the promotion was given when the respondent number 1 was not given even eligible as per rules.
Why this person has approached this court by way of writ petition?
Mala, these officers were superseded, and the association also took up the case of the entire officers of the PW department, because on their complaint to the Chief Minister, he formed a committee and they cancelled this promotion. And he went through this series of litigation, culminating in the Supreme.
The department has cancelled his promotion.
Yes, on the ground that
therefore he approached the court.
He approached the court in the first instance before the learned single judge. The learned single judge rightly held that he was demoted because there was fraud, because there were other cases. Then he went up to the division bench of this court. The division bench allowed his petition, and then the entire association and the officers who were superseded approached the Supreme Court. In fact, this is a reported judgment of the Supreme Court also on 19, and the Supreme Court passed this order. And
after passing of this order, what happened?
Well, after passing of this order, the petitioner thereafter was again brought down.
And then
he again approached the courts of the second instance, and where the learned single judge of this court has allowed his petition, but this was again appealed by the entire association, which is pending before Lordship for final adjudication.
It is pending
before a Lordship for final hearing. And in the meantime, he gets his promotion, and it is on the 24th of January that we could detect that the Chief Secretary.
Yes, sir.
In my humble understanding, Lordship,
First listing.
this is a PIL Lordship in disguise. Because he is aware that in service matter as PIL is not maintainable.
File your counter.
Lordship.
File your counter.
Lordship, I just see one judgment, Lordship, that's page 179.
179.
Yes.
Yes.
It's a WPC 551/2024 filed by petitioner Sri Deposit Das.
179.
171.
171, sorry.
171.
Yes, and it's
Yes.
a R. Heard Mr. K. N. Sudhuri in paragraph 2, Lordship.
Yeah.
The petitioner is presently holding the post of additional chief engineer in the Department of Public Works Road Department by a notification dated so and so, issued by the Special Commissioner and Special Secretary to the Government of Assam Public Works Department. The gradation list of the additional chief engineer civil PW was notified, wherein the name of the petitioner appears at serial number 2. It is the case of the petitioner that the person at serial number 1 in the said notification dated 11/1/2024 was already promoted to the post of chief engineer and has retired on 31/1/2024. The case of the petitioner before the court is that his case should be considered for promotion to the post of chief engineer in as much as there are 5 vacancies available in the cadre of chief engineer. The further case of the petitioner is that the regular inquiry by number so and so of 2017 is pending against the petitioner. However, till date, no search sheet has been filed. This court on 12/2/2024 directed the Learned Counsel, Standing Counsel PW to take instruction whether any search sheet has been filed by the file in the said regular inquiry. Today, when the matter is called up, the Learned Standing Counsel PW submits that no search sheet has been filed in the regular inquiry pending against the petitioner. Recording the submissions made by the Learned Standing Counsel PW, this court is of the considered opinion that there is no further impediment on the part of the respondents to consider the case of the petitioner for promotion to the post of chief engineer PW. Accordingly, the DPC is directed to consider the case of the petitioner for promotion to the post of chief engineer PW within a period of 2 weeks from the date of receipt of the copy of the order. Therefore, thereafter consequential orders shall be passed by the concerned authority.
Concern, it seems that pursuant to the order passed by this court, his case was considered for promotion.
Yes, but
And there is a categorical stand of the state.
the stand of the state.
No charge sheet has been filed.
Yes, well, no charge sheet as regards the departmental proceeding. But the regular inquiry was not answered to, because my entire case is that on when the chief secretary adjourned the meeting on January, he himself made, the selection committee
But
made a statement.
now, if the court order is there, that there is
In
no
this order,
impediment.
lordship, there is mention of
There is
only
no
one
impediment.
proceeding, that is the RE lordship.
The court has no further impediment on the part of the, to consider the case of the promotion on the post of chief engineer PWD. Accordingly, the DPG is directed to consider his case.
This is under challenge because I am not on the service part.
This is under challenge in the.
Yes, this is under challenge in retable 244, which is pending before lordship. The entire association has challenged it. And this relates to the service part. I am only on the vigilance part.
Let this find out when. Rate appeal number?
It's 244 lordship. It was in the yesterday's list lordship. The matter did not reach lordship. It will come in the month of June, lord.
244.
Yes, lordship, 2022.
Rate appeal number 244/2024.
23.
It is made clear that the question regarding the maintainability of the writ petition, the maintainability of the writ petition in the form of PIL will be looked into on the next date of hearing.
Well, not only on the 5th, I'll be out of station.
So we have simply said that list along with that.
Okay. Well, I'll seek an adjournment.
This is 2022 or 2024?
2022.
22.
Yes.
Against this order is of the year 2024.
Lordship, this matter was in the yesterday's list, lordship.
Against this order, you have any?
Not against this, not against this,
Not
lordship.
against this, in the association case, I'm told they have filed a miscase to
Lord-
bring on record that his promotion was in the meantime affected.
Lordship, page 134, lordship. This was
We are not on that. Well, we are not on the promotion. We are only on the
lordship, if
logical.
your lordship goes through this petition, lordship, this entire petition, entire submissions mainly on the basis, on the ground of his promotion,
No,
lordship.
no. This I
Entire
want to make it
documents,
clear.
lordship, except
If-
1 and 2.
Well, if-
Nowhere the petitioner submitted that particular RE registered lordship was on the basis of a complaint submitted by the petitioner. Lordship, kindly come to page
Well, in my prayer, I have not made any
Page-
statement. that
page
service issued
44,
only for 40 years
lordship.
got
One
his
page,
promotion.
lordship, page 44. That is the only complaint filed by the petitioner, lordship, but this is a different complaint, lordship. It was registered on 5/9/2023.
No, let them give
And
their
this
response.
complaint has already been closed, lordship, page 44, Annexure H. Annexure H, lordship, may kindly see name of the complainant, Khanin Deka. He is the petitioner.
No, this was not placed. This was sent to the CP Gram. CP Gram forwarded it to the PWD department.
That status is there, lordship. Rather, the Home and Political Department
Just one
closed the
minute, just
application.
1 minute, just 1 minute. The
appeal you are referring to, is it an appeal preferred against the order passed in WPC 1958 of 2021?
Yes,
and
it is
3021
page
of
134 of the petition. Yeah.
By that order, the learned single judge had directed a review DPC.
Yes.
Yes, and the benefits which were taken away in pursuant to the Supreme Court's order, that benefit was given on the finding of the learned single judge, which the association takes up in the division bench.
You mean to say learned single judge has overturned the Supreme Court judgment?
Well, that is not my case because that is from the record of the writ appeal which they filed. They say that the single judge could not have. That is their case, association's case. I'm not on the service part.
Mr. Council, until this order, the dated 16/2/2024, passed in writ petition number 551 of 2003 is under challenge. Can't help because his case was considered as per the
Yes,
direction of the court.
my case is not, I want to make it very clear. There's a misconception on the part of the respondent. I know my limitation. I'm not on the service part. I cannot.
What relief ultimately?
The relief is that because of the inaction and apathy for 7 years, can I not seek a writ of mandamus to know what is the final outcome of the case?
That they have already mentioned in this.
No, my lord, this is not the CP ground.
No
No,
charge sheet has been filed.
no, my lord, that is not.
That is wrong. It is there in the
My lord,
order.
this is their submission as regards departmental proceeding because the case.
Sir, this RE number 7812/2017.
Yes.
You were claiming that this inquiry, regular inquiry was initiated on your complaint.
Yes.
That regular inquiry, in that regular inquiry, no charge sheet has been filed, then what remains?
My lord, on that regular inquiry, the charge sheet, this is a submission regarding to his service part. Because the Supreme Court has said, they came to this court, I have examined their petition on the ground that 3 conditions were laid down by Janki Ram, that if there is a charge, if there is a pendency of a criminal case, and if there is a suspension.
Fine.
Our case was that a grave charge of a criminal investigation is before this vigilance, and they converted the preliminary, they got some material. That's the reason I made the police officer, the investigating officer also a party. Because on 2 occasions, on 16 and 2021, I was called to the office of the director, vigilance, and to the office of Ayakar Bhavan, income tax, to give my statement. I gave my statement. What I want, on the notice, they can't show
a single
anything.
statement that he was the complainant in that RE lordship. Not a single statement. The complaint is not there.
If it is assumed that this regular inquiry was initiated on their complaint, but
Yes.
ultimately,
It
when
can't-
no charge sheet has been filed till date,
No.
and if you want some
Lordship,
inquiry about
that is
your
the time.
complaint,
Lordship,
file
RE,
the RTI.
No, my lord, what has
File
happened?
the RTI.
My lord, if they give a response, my lord, on the next day, if they say that the RE is closed, my petition falls.
No, that is not. This.
Because, my lord,
this
what
is
has
the
happened, what I was
your
trying to
rights
impress
for,
the Supreme
filing
Court.
of, public interest.
My lord, what has happened? The Supreme Court in the case has clearly stated that in these matters, it is the High Court concerned who can look into this aspect. Because when statutory remedies were not available, you cannot move the Supreme Court. But when statutory remedies are available, I avail for 7 years, I'm waiting for it. Para 16 clearly says the High Court is the forum.
Having heard the learned concept of the petition for quite some time, we are prima facie view that this writ petition in the form of PIL is not maintainable, in which essentially the petitioners have raised grievance about the promotion of the number 12, respondent number 12 on the post of chief engineer. Full stop. It is noticed that the DPC has considered the candidature of the petitioner pursuant to the direction given by this court in WPC number 551/2024, decided on 16/2/2024. Stop. Came to know that the order dated 16/2/2024 passed in WPC number 551/2024 is not has not been challenged by any aggrieved party. Full stop. The petitioners are the private persons the petitioners are the private persons. Petitioners are the private persons who are raising grievance against the promotion of the respondent number 12 on the post
No,
of
not
chief
from-
engineer.
No, I want to make it very clear, my submission since 16, application was not on promotion, on corruption.
Though the concept of the petitioner is claiming that against, though the petitioner, concept of the petitioner is claiming that the petitioners are not aggrieved by the promotion of the petitioner, the promotion of the respondent number 4 on the post of the 12 on the post of the chief engineer, but from the averment made in the writ petition, it appears that essentially a grievance is raised regarding the promotion of the respondent number 12 on the post of chief engineer. Full stop. Then it concept for the petitioner we satisfy this court regarding the maintainability of the petition on the next date of hearing, put upon 29th of June. May, 29th of May.
It's May. Well, 29th of June, Lord.
May. 29th
I-
May
I'm on leave from 25th,
up to
up to 10th of June. 11th I'll be.
then we'll fix it in after summer vacation. Yes, just after summer vacation.
Item 33.
May I please? Lordship, order impunity is at page 50, Annexure A. Annexure 2. This is an order whereby the interim prayer, our interim prayer was rejected. Lordship, basic.
Page number 52.
Lordship, it starts from page 50 and relevant portion is at page 53.
Yes, sir.
Sorry, Lordship, page 54. Okay, sorry, page 53.
Just,
So our interim prayer was.
just. Yes, what's wrong in this order?
Lordship, what happened in this order? The Priyanka, it is relied upon the Priyanka International's case. That case there, at that point of time, when the Priyanka International case was there, the building bylaws 1998 was there. In that building bylaw, there was no provision for compounding the addition of extra floors to accommodate area within the compoundable affair. That provision was not there. Subsequently, in 2014 bylaws and the bylaws before that, this was added as a compoundable item.
Where is that?
Lordship, this is there in the building bylaws of 2014, which is applicable in our case.
2014.
2014. Lordship, it is against item number 7.
Yes.
In the Priyanka International judgment, the appendix prevailing at that point of time was quoted. There this in page number, this is in page para 41, the appendix was quoted there. In that appendix, this provision was not there. Subsequently, this has come
Which
and
is
our
the
bill,
provision which entitles you to get the regularization of the additional floors, which is that provision?
it is there in the appendix, this is there in the appendix 3 of the building bylaws that I have given 2000.
Read.
Lordship, that I have given copy I have.
Read. We are having this copy.
Actually, I have passed my copy.
This deviation all will come down to the. We said at the end of the time the pilot. Adjust to the.
It to page number 119. Which comes to be 200. Then if you permit. If there is about no material. Beyond the principle of
Mr. Nayak, where is the judgment? There is another judgment of this court, division bench judgment. Some matter in Sonapur. There are also 2 extra floors were constructed.
Lordship, here, Lordship, additional floor, Lordship may kindly take up the new building bylaws, Lordship.
So we'll come to that.
Lordship,
Do you have the judgment? This bench?
I'm sorry.
What is the meaning of FAR floor area ratio?
Yes, Lord.
Now, what he's trying to project that any construction which comes within the compoundable floor area ratio,
Lord.
that can be regularized or compounded on payment of penalty.
Lord.
And to support his argument, he is referring to Appendix 3 of the new bylaws.
Lord.
So first of all, do you agree with this, that any construction coming within the compoundable FAR can be regularized by payment of penalty?
Yes, Lord. So initially, Lord, if he got permission for ground plus 3, he constructed the fourth
Mr.
floor.
Nayak, the problem is you are neither allowing us to complete.
Lordship, the fourth floor.
No,
has-
you are understanding the question.
Yes, the fourth floor has already been regularized.
Correct.
Yes.
So fifth and sixth, does it come within the compoundable FAR?
No.
You make that statement by filing an affidavit.
Lordship.
Dismiss it.
Lordship, one more thing, Lordship, on the same issue, Lordship, two brothers are fighting in some writ petitions, Lordship. There also, Lordship, one IAS pending on the same issue, Lordship. They are claiming for status quo.
Then you have to say that this fifth and sixth floor doesn't come within the compoundable FAR. And this is the reason.
Lordship.
Subject to what he regards, will disclose the matter.
Lordship.
We can, Mr. P. Nayak, waste some time to file an additional affidavit, to the effect that the additional floors,
Fifth and sixth.
the additional floor, bracket में fifth and sixth floor, as will not come in the permissible FAR,
Compoundable FAR.
compoundable FAR as provided under the bylaws of 2014. Guwahati building bylaws of 2014. List on when?
1 week, Lord.
Third of June.
Don't take any action in 1 week, don't take any action.
Lordship, action has already been taken, Lordship. Some person has already been demolished.
Demolished when?
Much earlier, even before filing of the writ petition.
Some portion has been developed. We pray that further action should not be taken till.
Wait for 1 week.
Up to third, you wait for it.
Lordship, basically, it's a fight between the two brothers, Lordship. Same plot of land. If he is granted the additional floors, Lordship, then the other person will lose the affair, Lordship. That is the issue, Lordship.
You file whatever, you file your count.
We want to go to mediation.
Lordship, we tried.
On
but
last day,
that-
that was submitted before the learned single judge, Lord.
Lordship, that we are trying. So resolve the issue.
Yes.
Item 34.
My pleasure, Lordship. In this matter, I pray for little accommodation for today.
Yes.
Lordship, we are the Lordship's hand. I am for the respondent. A project of mine has got stuck because of PIL.
Is there any stay?
No, my lord.
That's.
No.
There may not be any stay, but the question is once the matter is sub judice, we are not being able to proceed.
What's the issue raised in this PIL?
I'll tell you briefly, Lordship, so permit. This is a park. I'm for the respondent. This is a park which is called Gandhi Bagh in the place called Silchar, south of Assam. So this essentially we have next photograph is now a marshy land, completely marshy land. So the Silchar Municipality Corporation floated a tender for development of that area and to generate some revenue. That process is now being challenged by them on the ground that it affects the environment. Now we have put it on record that the total construction that we are making is much below the threshold, which is required under 2006. Plus, we have also demonstrated that that area is neither a green belt, it is a semi-public area, semi-public area, which permits such activities.
We're not touching the park.
And there are, in fact, if Lordships, whenever Lordships find it convenient to hear, we have put all the maps and everything so that Lordships can have a feel of the matter that there's absolutely nothing to do with the environment here.
The request of the learning council for the. When is the
petitioner, this matter on 30th of June. 30th of June. 30th of May. Sorry, May, I'm sorry. 30th of May.
30th of May. Absolutely.
Public.
So it is not so much about green, it is also about taking up the only open area
No,
inside the
Lordship,
town.
I will, in fact, whenever Lordships hear that matter, in fact, we are trying to just develop that area. We are not building any concrete structures there. Please appreciate, this is a 28 bigha land. We are trying to enhance it. My learned senior friend who is appearing for the municipality will explain it, Lordships. There is nothing that is to be done. The 28 bighas, if when Lordship will see the photograph, nobody is using it. It's a marshy land. Whatever the municipality corporation is doing, is it going to serve public interest or not is the whole issue.
Constructing a park or what?
No, the park, it is an abandoned land, marshy land.
Oh, we are developing a park or what type of facilities you are going
Yes,
to develop?
that's an amusement park.
Amusement.
It is a water amusement park. We have put it on map what is going to be the constructions, and on either two sides, there'll be two. So,
Okay, we'll see.
yes, Lordship, please. Grateful, Lordship, but yes.
Item 36 and 37.
There's two April, my lord. There's really only one point, my lord, on the second 34, my lord, the interstatutory interest, my lord, whether after depositing the initial award, my lord. Initial award is passed under section 11 of the said act, my lord. And thereafter, my lord, what happened, my lord, the similarly situated person, they approached the authority and reference was there, my lord. And reference could awarded some amount, my lord. Initially, it was 0, my lord. Land value was 0. Subsequently, my lord, it was enhanced to 25. Other similarly situated person, they approached this reference code, my lord. Reference code awarded rupees 25, my lord, per square feet, my lord. And my lord, this petitioner, my lord, they approached before the district collector under section 28 of the Land Acquisition Act, the act, my lord. Initially, the district collector rejected their claim, my lord. Thereafter, my lord, under section 28 C83, they filed another petition to send for reference, my lord. And then, my lord, this matter was sent for reference court, my lord. Reference court, they awarded the same amount, my lord. And I'm reading the order of the reference court, my lord. This, my lord, page 124, my lord, is the award under section 26 of the reference code, my lord. Initially, when award was my district collector under section 11, my lord, the land value was 0, my lord. And subsequently, the reference code, they enhanced the land value up to 25 rupees per square feet, my lord. And reference code under section 26, the page 124, the award was given, my lord. District collector, the commission of scholarship shall predetermine the land value, the applicant under section 28A of LA 1894 at the rate of 25 per square feet within a period of 1 week from the date of receiving the certified copy of the judgment and award. And the applicant landowner shall also be paid 30% in addition to the land value, along with the interest of 12% per annum from the date of notification under section 4 of the Act to the date of the respective award of award number 1 of 2012 as per section 23 1A and 23(2) of the Land Acquisition Act 1894. And the district collector, deputy commissioner also shall intimate the general manager to satisfy the award of the third deputy chief engineer construction NF Railway, Silsar at Burberry. And the award, the state awarded amount shall be paid by the general manager NF Railway within a period of 3 months from the date of receiving the intimation from the district collector, Deputy Commissioner Scholarship, Mizoram, and in case of failing to pay the market and land value within a stipulated period, landowner shall be entitled to an interest applicable under Section 34 of LA Act 1894 with effect from 17 January 2017 till full and final payment.
Yes.
This is the award, my lord. My lord, thereafter, my lord, DC made assessment, my lord, and we paid the amount, said amount, my lord, said amount 2019, my lord, 2019. That was my lord, the gap 2017 within 3 months to up to 2019. That is a gap, my lord. That period they entitled 34, my lord. But thereafter, what happened, my lord? They filed execution case before the Scholarship district, my lord. In execution case, initially, this when we deposited the amount, my lord, then it was, my lord, execution case was closed, my lord. Against that, they filed an RFA before the ISOL bench, my lord, and when allowing the RFA, my lord, they restored the execution case, my lord. In execution case, my lord, they filed a civil medicine application claiming the interest under Section 34 and 23 1A 23 2 the interest part, my lord, from the date of possession, my lord, from the date of possession. Date of possession of the land, my lord. But when, my lord, the award under Section 11, my lord, Deputy District Collector award, my lord, immediately we paid the said amount 2013, my lord. We paid that amount, my lord. And now they're claiming the interest from date of possession till 2022, my lord. And in that case, my lord, the execution court, my lord, they pass an order. This order is, my lord, page 139. 139. Here, my lord, it is they are entitled to the interest 23 1A as per the execution code, my lord, and it was open for the petitioner to file an application before the district collector for claiming interest under Section 34. Then thereafter, district collector pass an order, page 154. Page 154, discussing the relevant portion is 156. Hard both parties and produce the authority of Honorable Apex Court and High Court as well. All the records of this court pertaining to an instant case has been gone through. It is no doubt that the instant case, both the parties do not dispute the interest under Section 34 of the Act 1894, which is a statutory in assert and entitled by the petitioner. It is found that a similar party with the petitioner's CMS so-and-so, who was paid statutory interest of the act from the date of possession till final payment.
Yes, he has allowed that then.
My lord, in this, when the district collector pass an order, my lord, to pay the interest from the date of possession, my lord, from the date of possession. Here, my lord, this award was, my lord, this award, my lord, subsequent reference quota award was under Section 26. And initial award was under Section 11 of the LA Act, my lord. When the land was acquired, my lord, initially when award was passed under Section 11, my lord, the railway, my lord, deposited the same the amount, my lord, on 13/3/2013, my lord. 13/3. That time the land value was 0, my lord. So that amount was, my lord, already, my lord, deposited and disbursed, my lord. They received, my lord. There is no delay payment, my lord. If delay payment, only, my lord, this award was 2012, my lord, and 2013. That gap may be, my lord. But we have paid already that amount in the year 2013, my lord. That amount. Now, my district collector, as per this order, the director deposit and the assessment was also made to pay the said interest from 34 interest from the date of possession of the land. That cannot be, because initially immediately Section 34. I am reading the Section 34 of this Act.
Section 34, this payment of interest.
Yes.
The old 1894 Act. When an amount of such compensation is not paid or deposited on or before taking possession of the land, collector shall pay the amount awarded with interest thereon at a rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. Provided that if such compensation on or any part thereof is not paid or deposited within a period of 1 year from the date of possession is taken, the interest rate of 15% per annum shall be payable from the date expiry of the period of 1 year on the amount compensation or part thereof which has not been paid or deposited before date of such expiry. Here, my lord, the district collector award was passed under section 11, my lord. And immediately, my lord, we have paid that said amount. So there is no delay payment, my lord.
How the learned single judge dealt with this?
Yes, my lord. Learned single judge, my lord. There's my lord, two cases was filed before the learned single judge, my lord. One is CRP and one is the writ petition, my lord. Both the hard matter and they passed this order, my lord. The relevant part starts from 2011. And before that, your lordship may this only this or I want to point out, my lord, when reference code they pass an order, my lord. Page 93, my lord. Some of the landowner under section so and so has claimed enhancement compensation before the reference code, which reference code had enhanced the compensation up to 25 per square feet, and there is also already comply by the relief authority by depositing the awarded amount by the state reference code and disbursed to the concerned landowner. That was, my lord, initial award under section 11 was deposited and disbursed, my lord. And subsequently, this one, when the execution court, they allowed to file another application before district collector. Thereafter, my lord, the order dated 11/11/2022, whereby the district collector, from the date of possession, the railway has to pay and as per under section 34. And my lord, this once learned single judge. Learned single from page 215 from the project made by the parties. 4 issues arises for consideration.
Yes, Mr. Once they have made the payment, then what is the question of interest then?
Look, there, in the initial award, there was no assessment on account of market value of the land. The market value of the land was not assessed, and therefore it was a nil award, as far as the land value is concerned.
Fine.
The reference court increased the land value to be assessed at the rate of 25 rupees per square feet.
Fine.
And accordingly, the award was drawn.
And they have paid the money.
No, they paid the first award where the land value assessment was not done. When the land value assessment was not done, that amount was deposited by them. But subsequently, the land value came to be assessed at 25 rupees per square feet. They discharged that liability, but not on the question arose whether on this amount, enhanced amount, interest will be payable or not. Your Lordship may kindly come to the finding of the learned single judge, my lord.
Yes.
That is that starts from paragraph 10, page 215.
Yes.
Well, the issues have been noted there.
Yes.
And as far as the question of whether the award will carry interest on it or not, the Honorable Court has referred to the judgment of the Apex Court in the case of Sundar versus Union of India. Your Lordship can kindly come to page 214, paragraph 7.
Yes.
Mr. Medhi so-and-so submits that since there is nil value of the landowners prior to the order passed by LA judge on so-and-so, landowners are not entitled to any interest under section 34 of the LA Act. He therefore submits that the execution court could not have directed the landowners should make their claim for payment of interest under section 34 of the LA Act before the district collector, though through the impugned order dated so-and-so. Insofar as the payment of interest on Solatium under 23(1)(a) and 23(2) of the LA Act is concerned, in view of the Apex Court decision in the case of Sundar versus so-and-so and Gurpreet Singh versus so-and-so, the landowner should be entitled to the same. He further submits that there is no basis for the district collector Kulasi to pass the impugned order dated so-and-so in awarding interest to the landowners under section 34 from the date of possession till the date of judgment and award by the LA judge. Now the question is whether the subsequent award of enhanced compensation will carry interest. So to say that whether the subsequent amount of award will relate back to the original award or not. Well, the answer is there in the judgment of the Honorable Supreme Court in Sundar's case.
This matter will require.
That is different, my lord. My lord, the VR, my lord, is the case 126, my lord. The assessment, we have paid
for the parties for quite some time. We are of the view that the matter requires consideration. Hence, admit. No need to issue notices, parties are already represented. No need to issue formal notices, parties are already represented. List this matter for hearing in due course. In the meantime, the effect and operation of the order dated 1/6/2023 passed by the learned single judge shall remain state.
My lord, this assessment made by interim prayer, my lord, in my page 42, my lord, assessment by the DC, my lord, but because the execution case is going on, my lord, on 24 execution cases there, my lord. Our deputy superior was false. My lord, page 42, my lord.
42. What is it?
This interim prayer, my lord. My lord, the impugned order, this is assessment 11/11/2022.
CRP number so and so.
This order
1/11/2022.
11/11/2022, 14/11/2022, and 24/11/2022. These are the assessments.
But there is also another aspect of the matter, my lord. The particular award which was challenged in the repetition was also part of challenge in the civil division, in a civil division filed by them.
My lord, it was there, my lord. It was there, my lord. The same, my lord. My lord, it was, my lord.
One by one.
Yes, yes, my lord.
And that civil division has also been dismissed by the common order. Now, as against the civil division, I mean, the order in the civil division, my lord, he doesn't have any remedy before this honorable court. The remedy is only available before the honorable apex court. The other aspect of the matter is that the particular award passed by the LA court, my lord, that was put to challenge in an appeal before the Isol bench. That appeal has also been dismissed. That was RFA number 16 of 2018.
My lord, it was earlier, my lord.
So that was also dismissed. Now in the
You will hear all these. The, in the meantime, the effect and operation of the impugned judgment passed by the learned single judge as well as the order dated 11/11/2022, 14/11/2022, and 24/11/2022
Of the district collector.
of the district collector Kolase shall also remain stayed.
well, can I request for an early hearing, my lord, in the
Yes,
just after summer
no,
vacation?
August, this matter for the hearing in the August 2024. August.
Item 38.
37. My 37 also same, my lord. It is admitted already, my lord.
Same order.
My lord, this only, my lord, in that case, my lord, what happened, my lord? District collector reject their prayer 34, my lord. This, therefore, they file a represent before this single bench on idle bench, my lord. That was, my lord, they allowed, my lord, to pay the 34, my lord. We have paid in same, my lord, immediately after, my lord, position, my lord.
We have already passed the stay order in this.
In the stay order is not there because contempt case is pending. my lord.
Yes, stay order is sitting at the night. First.
Stay of the single, learned single judgment.
Stay of learned single judge.
Yes, my lord.
In the second petition.
A single judge as well consequential or consequential assessment of the district collector, my lord.
So we have already ordered that.
My lord.
We have already ordered that.
Yes, my lord. Single judge as well as the district collector pays, my lord, 172, my lord.
What my representative wants to submit, my lord, if I'm not mistaken, it's a different petition. It's a different order. That's what my.
Different order. Okay, different order, no. Yes.
If
My lord.
May please, your lordship.
Lordship, here I need 3 weeks time to file affidavit, Lordship. I received instruction yesterday only
And consent for the respondent number,
for all the respondents.
all the respondents seek some time to file counter to the appeal. Time period for the response. Yes.
Of the item.
High level.
Item 39.
May previous lordship. Look, this Tomato PL has its origin to a mob lynching incident happened in Teju, Arunachal Pradesh in the year 2018. Lord, thereafter, the scope of this PL has been, Lord, enlarged by this honorable court. And last directions were like installation of CCTV camera in all the police stations, as well as integration of data contained in NAFI software along with the e-prison software of the respective state. So far as Mizoram is concerned, my lord, they have filed affidavit wherein they have started doing this, taking, you know, biometrics and fingerprints in and uploading in the NAFI software. My lord, there is some problem with Arunachal, my lord.
Yeah.
Assam, my lord, also is uploading in the NAFIs, but integration is not there with the e-prison software. And there is a time lag of 24 to 48 hours. This honorable court initially wanted to happen in real time, my lord.
This is covered under the CCTNS.
Sorry, my lord.
Is it covered under the CCTNS program of the Home Ministry? You are not aware?
No, my lord.
Please check it up. Now all these things are irrelevant.
Lord.
There is something called CCTNS.
Lord.
And that will take care of everything. And the Guwahati High Court is very much hooked into it. So that means all the states coming under Guwahati High Court is in the ambit of that. Huh? Unless you do a little study, you may not be able to handle the queries.
Definitely. Yes.
So what do you want now?
Lord, Lordship will give some time and
Standing counsel for the Guwahati High Court takes some praise for some time to update his instructions.
Mr. Das, take note, ICGS and CCTNS. Please do some research on that. You will find answers to many of the questions.
Yes, my lord. Yes. Deeply over.
Yes.
Item 40 to 42.
Yes.
May please your lordship. In this case, as per direction of this honorable court lordship, I have filed one affidavit lordship. Direction is on 8/4/2024 lordship. Paragraph 3 of my affidavit lordship.
You already filed.
Yes, filed.
Yes.
Lordships, Mr. K. N. Chaudhary, I've been led by Mr. K. N. Chaudhary, sir, who's on the way, Lordships. I may be accommodated.
Would you like to?
Lordships, it may be kept in abeyance or a long date may be fixed, Lordships. Meantime, if they modify the rules, then we
You have
will be.
already filed this affidavit of this effect.
Yes, Lordships, they have filed the affidavit, but till the rules are amended, Lordships, it may be kept.
Sorry, my lord, they have filed an affidavit where they say that till the rules are amended, they will, make a selection of candidates based on the marks without being, whatever. If that is so, perhaps our, grievance is answered, my.
Then what remains in keeping this PIL pending?
It can be closed, my, or lordships can keep it for some time. Let us see, my, let the matter come after 2 months. After the summer vacations.
If after that, if they have assured it and if they'll not do it, then again you can approach this.
But that liberty may be reserved for us.
That liberty, yes.
Yes.
Issue is common all this, in all this.
Yes.
In all these petitions, issues.
Common, my lord, common.
The petitioners are all from Chakma community.
Sakma community.
And they are aggrieved by the.
That's stipulation in the rules.
Stipulation in the rule.
Rule 5.
Which does not.
No, my lord, on one hand, our quota has been restricted and the quota for local mesos have been enlarged. Now they say will not go by any categorization. All mesos, so all tribals of the Mizoram will be treated alike. So that was our case.
Okay. These PIL petitions are filed.
Not PIL, sorry.
This PIL, the PIL petition number.
Local permanent.
No, so the writ petition number 285/2022 and other connected writ petitions are filed by the petitioners who are belonging to Chakma community of the state of Mizoram.
It was into file. I think
Essentially agreed by the action of the state government.
Stipulation in Rule 5.
In fact, we challenge the rules, my lord. Validity of the rules.
Challenging the validity of Rule 5. Challenging the validity to the amendment of the.
Challenging the stipulations contained in Rule 5 of the.
Challenging the stipulation contained in Rule 5 of Mizoram in bracket selection of candidates for higher technical courses bracket close rules 2016 whereby
a distinction has been made.
Whereby a distinction has been made in between between the Chakma community.
No, local Mizo community and
local Mizo community
and the other tribals.
And the
other non-Mizo, they call it Jo, my lord.
Non-Mizo
scheduled tribes.
Scheduled tribes, including the Chakma.
Non-Mizo
Non-Mizo scheduled tribes.
Non-Mizo scheduled tribes non-Mizo scheduled tribes, including the Chakmas.
Yes.
Full stop.
And but
the
in the
direction-
presidential order, my lord, they're all scheduled tribes of Mizoram.
Pursuant to the direction given by this court on 8/4/2024, the state of Mizoram has filed an additional affidavit on 15/5/2024 in WPC number 285/2022, wherein it is stated that the government of Mizoram Higher Technical and Education Department intends to amend Rule 5 of the Rules of 2016 and as an interim measure, the government Mizoram will make allotment of seats under the state quota meant for ST local permanent residents of Mizoram candidate purely on merit basis. Full stop. The relevant portion of the additional affidavit is quoted herein, para number 3. In view of the categorical assurance given by the state of Mizoram in its additional affidavit, in the additional affidavit filed on behalf of the respondent number 1 and 2, we are of the view that for the time being, the grievance raised by the petitioners in these writ petitions has been resolved and has been resolved, and therefore no further order is required to be passed in this petition. However, we make it clear that if the Rule 5 of the rules of 2016 is not amended as intended by the state in its affidavit, and if there is any violation to the interim arrangement as indicated in the affidavit, the petitioners are free to approach this court by way of filing appropriate proceedings.
Definitely. All writ petitions disposed of, and all IAs also disposed of. Right? And
Everything.
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 In the petition, intended in the affidavit, as projected in the affidavit.
There are 3 petitions, my lord.
Projected.
I am lines director, learned counsel to both the parties are also in agreement. For the time being, their grievances reserved. Learned counsel to both the sides are also in agreement with the said position.
That for the time being there. Yes.
Deeply obliged.
Item 44.
Your consultant.
May I please.
Yes.
Lordship, matter pertains to recruitment in NRL, Lordship. I filed my
NRL,
reply to
yes.
yesterday, Lordship. I filed an affidavit, Lordship, and to that I have filed my reply yesterday.
You filed
Lordship, I have objected to their amendment they seek to make, Lordship, making 30% reservation for candidates that are sponsored from Employment Exchange Golaghat. Earlier, 100% was for,
Then they have reduced it to the
100% was reserved for candidates who come from the Employment Exchange Golaghat, Lordship, not making it open, Lordship. I challenge that rule. Subsequent to that, they had made some amendment, Lordship. By that amendment, they want to make.
Your clients are not proposing to settle down in Golaghat permanently.
This Article 16 is.
Ms. Verma, we'll have to see whether this comes within the sweep of Article 16 of the Constitution, which prohibits any kind of discrimination on the basis of caste, creed, residence, religion, nothing. That is where you have a stumbling block. So till we decide, you can't implement it.
So I understand that, Lordship. I've gone through various judgments. I had a word with my client's Lordship. We are of the, subject to Lordship's orders, if Lordship decide to set aside the rules. So
So
it would be,
if we set aside, then it's okay. Otherwise, you're not going to do anything on your own,
Lordship,
despite knowing this, that it is violative.
Lordship, we cannot, we have some difficulties on doing it on our own because there are too many stakeholders involved, Lordship. So if we have orders from the court, Lordship, the only there would be some consideration if can be granted, Lordship.
Having heard the learned concept of the parties, we are of the view that matter requires consideration. Hence, list this petition for hearing in the month of September 2024. However, in the meantime, the respondent Nominee Refinery shall not reserve 30% of the
Give effect to the, give effect to the scheme.
scheme policy.
You have come up with a regulation, is it?
Yes, Lordship, the amendment which we have already placed on record in our affidavit, Lordship. We filed on.
Page
30th
76, Lordship.
Page 76.
Yes, Lordship. Which was taken pursuant to the orders of this court on 28.
Shall not give effect to the clause number 7.1.
Lordship, 7.1 and 7.1.2, Lordship.
7.1.2 and 7.1.2
Under 7, Lordship, clause 7, source and procedure of recruitment.
under clause 7, that is source of procedure for recruitment
At
till next date.
Amended clause 7.1.1 and 7.1.2. Sarajit to bole that is so procedure and recruitment.
Procedure.
Page 76 से forward to.
Page 76 पे देख लेना है.
Item 45.
May it please your lordship. Lordship, this matter relates to appointment of special public prosecutor in the POCSO court, Borpeta, lordship. If lordship comes to page number 28, lordship. 28, lordship.
Yes.
Lordship, what has happened is that the fact of the case is that two posts are vacant in the Borpeta court, lordship. One is of the additional public prosecutor and one of the special public prosecutor, POCSO court. Well, lordship, if it comes to page 28, this is the list of names of the advocates who were forwarded by the Borpeta Bar Association to the district judge for appointment as different. So if lordship comes to page 29, here is another list is the list of the for additional public prosecutor. Now these two lists are, if lordship comes to page 30 now, by this letter, the district judge forwarded the letter names of these two lists to the state respondents, lordship.
Who requested the district judge to forward the names?
Lordship, the district judge has called for the names from the bar.
They requested the district judge to forward the name.
This was done as per section 24(4), lordship.
24(4) of this.
CRPC, lordship.
Read. Yes.
Lordship. The district magistrate shall, in consultation with the session judge, prepare a panel of names of persons who are in his opinion fit to be appointed as public prosecutor or additional public prosecutor for the district. Now, if
That is for the public prosecutors and additional public prosecutors, not for the special prosecutors.
I'll come to that, Lordship. I'll come to that, Lordship.
Yes,
Now, Lordship, this next clause 5, Lordship.
yes.
No person shall be appointed by the state government as the public prosecutor or additional public prosecutor for the district unless his name appears in the panel of names prepared by the district under subsection 4.
So
If the name is not there, he cannot be
not there, he can't be
appointed, Lordship,
as additional public prosecutor or prosecutor.
as public prosecutor, Lordship. Now, if Lordship takes up the POXO Act, Lordship, section 31 and 32, Lordship.
POXO Act, okay. Yes,
Section 31, Lordship, of the POXO Act.
same as otherwise
Provided the provisions of Code of Criminal Procedure 1973, including provision as to bail and bonds, shall apply to the proceedings before a special court, and for purposes of the said provision, the special court shall be deemed to be a court of sessions, and the person conducting a prosecution before the special court shall be deemed to be a public prosecutor, Lordship.
apply to the proceedings before a special court.
Yes, Lordship.
So is this appointment of a special public prosecutor comes within the purview of proceedings?
No, Lordship. Now, if we come to section 32, Lordship.
Yes,
The state government shall, by notification in the official gazette, appoint a special public prosecutor for every special court for conducting cases only under the provision of this act. Clause 2, Lordship, a person shall be eligible to be appointed as a special public prosecutor under subsection only if he has been practiced for not less than 7 years as an advocate. This is one of the conditions, Lordship. Second is, every person appointed as special public prosecutor under this section shall be deemed to be a public prosecutor within the meaning of clause U of section 2 of the Code of Criminal Procedure 1970, and the provisions of that code shall have effect accordingly, Lordship. Now, meaning thereby, Lordship, if we come to 2U again of the CRPC, Lordship, public prosecutor has been defined here, Lordship, to 2U. Public, Mayor, Lordship.
Yeah.
Public 2U, public prosecutor means any person appointed under section 24 and includes any person acting under the direction of a public prosecutor.
that's not the different thing.
Now, if I may, Lordship.
That shall be deemed to be a public prosecutor, that is a deeming clause, but that doesn't mean that the procedure for the appointment of the special public prosecutor has to followed as per the this section 24 of the CRPC.
Lordship. But Lordship, if I may, then please one, I have a judgment of Supreme Court, Lordship.
Yeah.
For a moment, Lordship takes up the PMLA Act,
Okay.
Prevention of Money Laundering Act.
What do you want?
There's one section, Lordship, section 46, which is perimeter to this section 31 and 32, Lordship.
Yes.
Section 42, and I have a judgment in regard to section 46 of the
PMLA Act.
PMLA Act, Lordship.
Section 46.
Yes, Lordship, section 46 of PMLA Act.
Application of the, yes,
It's a
Yes,
perimeter provision of 31 and 32, Lordship.
yes.
Now, if Lordship comes to paragraph 15, this is regarding appointment of a public prosecutor in the 2G scams, Lordship.
We,
Now, if Lordship here, paragraph 17, section 46 has been quoted.
yes,
Then paragraph 18, the provisions of 2U of criminal procedure has been quoted, Lordship. Accordingly, at 1924, section 24. Now, if Lordship comes to paragraph 20, Lordship,
yes.
may I read, Lordship? 2012, 3 SCC 117. May I read paragraph 20, Lordship?
Yes.
From a perusal of section 46(1) of the said act, it appears that every person conducting prosecution is deemed to be a public prosecutor. At the same time, section 2E of CRPC makes it clear that any person who is appointed under section 24 CRPC is a public prosecutor. Therefore, on a conjoint and harmonious reading of section 46 along with section 24 CRPC, it appears that the expression person conducting the prosecution before the special court in subsection 1 of the section 46 of the said act would mean that such a person must either be appointed by the central or the state government after following the procedure prescribed in the subsection 4, 5, along with subsection 7 of the section 24 of CRPC, or in the alternative, after following the procedure in subsection 6, read with subsection 7 of the section 24 CRPC. We are of the view that both the provisions, namely the provision of section 46 of the Act and section 24 of the CRPC, must be read together, since section 46 of the Act, being a letter act, makes an express reference to the provision of the pre-existing central law, namely the provision of the section 24 CRPC lordship. Yeah, 24. This is my guess, lordship. Now they have appointed someone whose name was forwarded for the post of additional public prosecutor, not the special public prosecutor, lordship.
Yes, sir.
Section 32 here is completely different provision of this POCSO Act matter. Section 32 as such doesn't make any lay down any procedure of appointment. Let me read
Material to section 46 of the PML Act. Section 32 is very material to the section 46 of the PML Act.
46.
Yes. (31) and 32.
My lord, I'm just reading section 46.
This 46(1) is perimeter to section 31.
46(1), yes.
It is verbatim section this 31.
This judgment, I have not gone to, let me go to the judgment of the Supreme Court. I'll just come back. Make it change. Monday. I'll read the judgment. That will be taken up on Monday, man.
And counsel for the petitioner has placed reliance on the decision of the Honorable Supreme Court rendered in Center for Public Interest Litigation and Other Sources, Union of India, reported in 2012, 3 SCC 117. Stop. In support of his argument that
117,
without following the procedure as laid down under section 24 CRPC, no special public prosecutor can be appointed in the POCSO court. Learned counsel appearing for the respondent prays some time to complete his instruction. Mr. Mehta prays some time to complete his instructions. Majumdar, sorry. So Majumdar prays some time to complete his instruction. D. Majumdar. And pray for his granted. List on so and so. Monday.
I know.
Supplementary list for orders item 57.
Your Lordship, I have for set aside and quash letter issued by the respondent number 6. During the pendency of this connected read table, respondent number 6 issued notice to the appellant. And this is the page on the head.
IA in the writ appeal.
Yes.
Yes, Mr.
This is a separate cause of action, madam. How can it be through an IA, madam?
What was the, what he he has filed writ petition for what?
Read petition, madam, prayer 27, at page 27, madam.
You just don't have, writ petition was filed for what relief?
He was placed under suspension, that was ultimately revoked. He has been placed in his original post of posting, madam.
In the writ petition?
Yes, madam.
The court has granted the relief.
Yes, my lord.
And this appeal by.
If your lordship come to page 79 for a time being, my lord.
He is not in Utti anymore. The writ petitioner,
Yes, my lord.
he has been given posting in the original post.
Yes, my lord.
So, but he is having the documents of Utti ME school. Is that the problem? Why this impugn order 75/2024 has been issued?
My lord, that is a space 12, my lord, the prayer portion.
Oh, we know that. What is this document, page 10 in IA? What is it about? Are you aware of the case?
Yes, my lord. Actually, my lord, this is an elementary education, my lord. I am for the state, my lord, 4 and 5.
Don't know what is the case. That's all.
There is a page 9, my lord, of the IA, my lord. 10. He has not handed over the relevant document to the school, and that has been accepted.
Listen, there is an order of the learned single judge.
Yes, my lord.
Reinstating him, restoring him.
Yes, yes, he had joined also, my lord.
Yes. Then why this has been issued? This order has been issued.
That is from elementary education can be entered, my lord, sir.
Why this petition is in fact allowed? You are Mubarak Hussain.
Yes, Mubarak Hussain.
So how you are aggrieved by the order of the learned single judge 4/3/2000?
My post is reinstated. His original post as a IC headmaster, but learned single judge ordered passed order as a assistant teacher, original post.
This learned single judge is taken into consideration. Under such circumstances, in charge headmaster shall permit to petitioner to join in his original place of posting of assistant teacher in Putukati, ME school, Rupai Naugat. The department will also issue consecutive director in charge and permits on to in view of the above, the petition is still disposed of. So for what you have filed this petition? You have filed the petition for what?
I'm praying for in this petition that I have reinstated my original post as a IC headmaster.
As a headmaster?
Headmaster. But they have reinstated my service as a assistant teacher.
And you have admitted before the learned single judge, yes?
No, I have not till joining. His notice already issued, my lordship.
Notice?
In written notice already
No,
issued.
the bill is thing there. That's right.
My lordship, during the pendency of the writ appeal, no further.
Just a minute. Block elementary education of Islamic
अपना ये तो रिकॉर्ड जो है ये ऑर्डर वही तो बात है
Where is your senior?
My seniors have some personal issue too.
File your response to this IA. Mr. Majumdar, says some time to file. I'll reply to the IA. Number 1482. List after 3 weeks.
For admission, item 58.
Wait, please, Your Lordship. And of this, with the appeal is by selling the order dated 4/12/2023, whereby the status quo order was placed on the tender of 18 November 2023. My limited grievance before Lordships is that before the learned single
order.
judge, yes,
Status quo order.
status quo order was passed in respect of a tender in which the petitioner had not participated therein. Madam,
That's right, but in fact, a connected writ appeal, we have already decided some.
Here, my lord, this is separate case. Here, my lord, they have filed a application for vacating the stay. And your lordship will kindly see the last.
That is this is matter in relation to supply of 2 ambulances.
No, this is same party, but different.
bus
different
and bolero vehicles.
Bus and bolero.
One
This was settled for 2 years and extendable by another 1 year. So after 1 year, my lord, they said your thing will be, your contract will be terminated and they have issued NIT without any show cause, without any. We came before the court, my lord, to maintain status quo. So, and thereafter, my lord, they filed an application for vacating the stay. And vacating the stay order, your lordship will kindly see page 158. This is the order person, the writ petition is now fixed on 27th. This is the order they have impugned while in the vacating petition, page 158. They say this.
That is an order, 2 orders they
Mentioned
passed.
for the motion urgency involved as per the petitioner, this court has allowed the petitioner to be listed.
This is the mistake they have filed because now they are saying there was some mistake and all in writ appeal, they are saying
without me.
that some clerical mistake is there. The impugned order
The
was
clerical
not
mistake was corrected. My contention is that not for the vacation of the interim order per se, but for the closure of the entire writ petition on the concession of the IOCL, that we are allowing him to continue complete his contract period. His writ petition prayer itself says, let me continue my complete contract period. I'm saying conceded. Let him continue. Let him, on 27 May, his contract period is getting over.
Okay.
There is no prayer for extension of his contract period in the writ petition.
Fine.
After I've taken that objection, they file a belated writ petition seeking extension for further 1 year when the contract clause itself says it may be extended by 1 year subject to the satisfactory performance by the contractor at the discretion of the corporation.
Fine.
2 riders, my lord, may as well as subject to satisfactory performance. I have conceded on the satisfactory performance part, and I've also before on that when the writ petition was listed, I've also submitted before the honorable single judge that they may be permitted to participate in the tender process. The bids are still open. Technical bids are not evaluated as on date. They have 2 years work experience, satisfactory performance record, and brand new vehicles. But before the honorable single judge, they said that they did not want to participate. They want an extension. Now, my question before your lordship is that.
And in that petition, the court has stated state the new tender process.
The new tender process is already a status quo. There is no further interim order. The fresh petition for extension came up today before the learned single judge, and I had fixed it on 27th of May, along with the earlier writ petition as well. So there are 2 writ petitions now pending, one for completion of the contract period, one for extension by a further 1 year. My simple limited grievance is that the IOCL may be permitted to continue with the evaluation of the tender process because that also takes another 20 days. In the meantime, if the tender is forced, he gets to continue. His extension period is allowed.
Monday. No, it's the 28th.
We'll fix it on 28th. Let us see in the petition whether extension is granted or not.
On 28th. Well, 28th, but at least we will not,
Tendency of this appeal shall not be a bar for the largest single judgment.
List
Malad,
on-
they have already
list on-
violated
list
the
on-
order.
Just a minute, sir. List on 28th of May 2024. However, it is made clear that pendency of this writ appeal will not, shall not,
Constitute a bar,
shall not,
constitute any bar.
shall not treated as a bar in hearing of the writ petition number
7005 of 2023,
7005 of 2023 and
2615 of 2024.
2615 of 2020, writ petition numbers.
Madam, the IOCL may be permitted to at least continue with the evaluation without disclosing any result or issuing any LOI.
Let the matter become on 28th, we'll consider it. Suppose his extension
During the-
application
Malad,
is
during the
not granted,
pendency of the-
then
Pendency of the case, they have violated the order. I came to know only today.
what
That I
violation?
will- They will be filing contempt or something.
That is there.
Complaint.
Item 59 for hearing, court order matter.
तुम्हारा डॉक्टर
In this case, now hearing is almost over. I may have one personal difficulty. I'm not very sure as to whether I can appear. But on an earlier occasion in 2016, I appeared in my individual capacity, in my private capacity. I was not an additional AG at that time. For the petition number 2.
Forget it. Now wasted right only. We are concerned with that. We have already completed the hearing.
Yes.
We are not going to adjust.
My lord,
it.
my lord, I'll just take 15 minutes time, my lord. Before I make my submission, let me respond to one query which fell from Honorable Justice Shyam the other day, whether I am also pressing Article 14 or not.
Yeah.
Now, my lord, per se, so far as the amended rule is concerned, we are not challenging it on the ground that it is violative of Article 14. But insofar as, my lord, consequence which has ensued qua our vested right or existing right, there is a violation of Article 14. To that extent, we are laying a challenge, not qua the rules per se, independently, my lord.
Yes.
So therefore, our case is, my lord, in the event lordship comes to the conclusion that we have a right and in enjoying or considering for promotion, etc., which is to take place in a future date, in that case, if there is, it comes in the way, then to that extent, there is a violation of the Article 14.
Yes.
Not, my lord, the rule as such that this is violative of Article 14 because you have created a separated class, not on that count. Now, my lord, please take the
That was the sum and substance what you have argued yesterday.
No, my lord will kindly take the rules, my lord, at page 93. I am referring to one of the rules. Now, the other day, your lordships also perhaps wanted to say the earlier there was no rule, now there is a rule.
Yeah.
Now there is a repealing and savings provision.
Yes.
Please come to page number 102, my lord.
Yes.
The orders corresponding to these rules and in force immediately before commencement of these rules are hereby repealed, provided that all orders made or actions taken under the rules so repealed or under any general order ancillary thereto shall be deemed to have been validly made or taken under the corresponding provisions of these rules. This is no exception. It is akin to Section 6 of the General Clauses Act. The actions taken
Because of 29. This rule will save all of this. Integrated cadet type. That's what. Obviously, it's safe. Even if this is not being the same.
That is automatically saved. Even if this clause is not there, all action taken under the previous rules.
Will be saved.
Will be saved.
Yes. Now, another important aspect is, please come to page number 93. There is no intention in this rule to apply retrospectively. Page 93. They, 1, 2. They shall come into force on the date of their publication in the official gazette. Naturally, this is the date post 2nd of March 2016. So, my lord, there is no express intention
To implement.
to have retrospective application.
But sir, the only question now
No, no, I'm coming to it, my lord. I'm articulating my argument. Now, lordships wanted to take a view. The two judgments which I cited,
yes,
lordships perhaps wanted to say that here some rights are there. Having been, maybe somebody have been appointed, maybe somebody have been conferred some benefit. Now that cannot be taken away. That is what is saved by
vested. What is the exact meaning of vested right?
Yes. Now, my lord, yes.
That is what
Precisely.
happened in R.K. Kapoor versus State of Haryana.
Exactly. My lord, as far as the legal proposition is concerned, there can be no opinion about that. That's the fact. If something is to happen in future, perhaps to that my claim that there is a vested right, that may not hold water.
One more thing.
Yes.
What is the criteria for this promotion to the post of director?
My lord, it's a selection post. No, sorry, seniority come merit.
Seniority come merit.
And my lord, there is one more requirement. Seniority come merit.
This whole process is confined only to the planning. There's a roughly.
Yeah, heavy number.
I don't remember going to Quota.
Because of the High Court order. High Court order is the one I get. Very good.
दोनों consider नाता की बात इसको promotion मिला नाम तो अलग है but it's consider
No, अपना कहते हैं
individual minister
I go to other vision.
Mr. Chaudhary, just to cut the long matter short and put it things in the perspective.
Well-
You see, other arguments we have understood, we appreciate your arguments. The only question here is, as you have also projected, your case is that by introducing the rules which disconnects, delinks the other two channels from the promotional post, a vested right has been taken away. Tentatively, this is what is going through our mind. We must tell you. You may address your argument. You see, we could understand that if Mr. X individually would have approached this court and said that on the date on which these rules were notified, I was one of the few candidates who would come within the zone of consideration for promotion to the post of director. Therefore, by bringing this rule, the right that I have of being considered for the post, that has been taken away. Then also, by extending the principles of vested right, we could have taken it into fold. But the problem here is this. This is an association. All the members of the association will never have the vested right to be promoted. Correct. Now, whether a particular person has the vested right or not, that will depend on his own fact situation. When was he appointed? What is his claim? What is the nature of his stake? This thing cannot be assessed if you make an omnibus claim, which is related to be relatable to a right of a class of employees. Class of employees is one thing, and vested right.
I've understood the question.
You have understood the question,
Yes.
no?
Please
That will
come
have
to-
a decisive
Please
factor in
come to
this matter.
para 19 of the writ petition.
All right.
My lord, yes, as a general proposition of law, when it is a service matter, how far an association can espouse.
No,
because
not
of its
even that,
members.
not even, let's take
Yes.
it that the association can come.
We
The answer has to be
pointed
given,
out that very aspect, my lord.
the
Yes,
answer has to be given on the basis of the claim of the individual who says,
correct,
my right has been
correct.
taken away.
Page 16, para 19.
Yes.
Yes.
That it is stated that one of the member of the petitioner association, Sri Nogen Kolita, superintending engineer, who has got postgraduate degree in planning, had raised the issue of eligibility of promotion to the cadre of director from superintending engineer before this honorable court. This honorable court in judgment and order dated 13/12/12 in writ appeal number so and so held that the post of superintending engineer is equivalent to joint director. It was also held by the honorable court that Sri Nogen Kolita is eligible for the post of director. It is stated that the impugned town and country planning engineering service rule 2016 has been notified against the spirit of the judgment and order dated so and so in writ appeal number so and also in violation of the observations made by the honorable court just to deny promotion of the eligible engineers having postgraduate degree or diploma in planning to the cadre of director and to give undue benefit of promotion to the town planners to the cadre of the director. It is pertinent to mention here that alongside the state respondent, planners working in the directorate through their association were also one of the respondent in the writ appeal and became unsuccessful in their attempt to restrict the superintending engineer from promotion to the cadre of the director. We came out with specific case. This is our case. We are not espousing any general cause. We gave a pointed, my lord, example that this is the person, he is also having the degree of planner.
But this is in the context of the executive instruction. The rules were not there. When the division bench had passed this order in writ appeal,
Yes.
at that time the rules were not introduced.
Exactly. That's why, my lord, yesterday I made the submission that whether this rule is a validating legislation to take away the basis of this judgment. Answer is no. In that situation, what will happen? My lord will kindly appreciate every case, it has its own peculiar facts. My lord, yes. If today I am non-suited on the ground that your no future right of yours is sought to be taken away, I'm satisfied, my lord. There I may not have a case, but here in this case, my lordship will find. In fact, after the judgment, I was appointed as director in charge. Thereafter, my lord, because of the rules, I was replaced by a person from the planning department.
Where is that? He should file the case, then your case.
That
will
is
be
true, my lord.
Covered under RK Kapoor. That should have been challenged.
That should have been challenged.
That is squarely a case where the vested right is taken.
No, my lord, my humble submission, well, subject to what your lordships may say, my lord. In that case, every time a person comes, the person is, not favored with, everybody will have to come up with a writ petition.
Not everybody, if a aggrieved person comes and court gives a ruling, then certainly that would apply in the future cases also.
What I'm trying to say is, when in a public interest litigation, the Supreme Court says that normally in a service matter, PIL should not be filed, I can appreciate. But it is a writ petition where, my lord, having faced with a situation where the writ petition has been filed by an association, I'm trying to argue in favor of maintainability of the writ petition.
So Chaudhary, we are not on maintainability. We are taking a very liberal approach here.
Yes.
But you cannot formulate a legal doctrine. Yes, unless the individual comes and says that this was my right. For example, the person you referred.
Yes.
If he was appointed as director.
Yes,
he is the one who should approach the court. That is a case which is covered under.
His right has been taken away. He's a member of the association. And association is, my lord, registered. And our High Court has said that if it is, as long as it is a registered association, he can maintain a writ petition.
No doubt about it. But not for the individual rights, sir. Collectively, certainly, there are thousands of members of this association.
All right, my lord, let me have the instruction of the clients, whether they would like to withdraw this and file it individually. Let it come up on Friday, madam.
Otherwise, I have come up with a judgment which has directly dealt with this issue of vested right. And just one.
No, Mr. Murthy, is it correct that someone from the stream of superintendent engineer was appointed as director?
Yes.
And then he was relegated after the rules.
In charge.
That
No. Till date, my lord, because there are so many litigations were going on, no substantive appointment has been made for the last maybe decade.
Mr. Supply the copy of the judge.
My lord, and just may I read just one page?
Okay, read.
2019 4 SCC. My lord, I have given a list of books. The book is available with your lordship. Page 319. Krishna Kumar.
2019.
4 SCC. Page 319. But I gave a list in the morning. This book is available with your lordship. Page 319. Para 10 lordship may kindly have it.
Yes.
In considering the rival submissions, it must at the outset be noted that para 10 I am reading. That it is well settled that there is no vested right to promotion, but a right be considered for promotion in accordance with the rules which prevail on the date on which the consideration for promotion takes place.
That is elaborately discussed with Ajit Singh too. Ajit Singh.
Yes, they are
elaborately
also
dealt
method,
with
yes.
this. Then
In
what
Ajit
is
Singh
it?
too also it is discussed. Here specifically it has dealt with one issue, my lord. Because this in that 1983 Rangai judgment has been relied on by several in several cases, but it was distinguished. Lastly, by the latest judgment of 2023, my lord, it has been overruled, where it was said that a post falling vacant prior to the amendment of rules will have to be filled up in accordance with the rules prevailing at that time. That has been overruled in 2023, where this
Rangai has been
overruled. And this judgment has been referred with approval in 2023 also. There it has been specifically said, because ultimately what is argued is, my lord, at that time when the rules were prevailing, they should be applied to me. This argument has been, my lord, overruled, rejected. And it has been clearly said that you will have to follow the rules, the department will have to follow the rules existing on the day he is considered for promotion. He is yet to be considered for promotion. That way,
Mr. Mazumdar, that is why we have been pointing out that if an individual would have come before us saying that
absolutely, madam.
had these rules not been framed for another 2 months,
Yes.
I would have been considered for the post of
Then
planning.
that's a different
Then
thing.
we would have probably
Consider it.
Well, this is one aspect. And another submission my learned friend just now made, that there is no indication, if you go by the rules, there is no indication that it will apply retrospectively. When the question of retrospective operation is not there. We are not saying that this rule will apply retrospectively. It will apply absolutely prospectively, and it will apply on the date when a person is considered for promotion. On that day it will be applied. Not that we are going to apply it on a previous date, my lord. Yes. So
My
that
lord,
this judgment is
My lord, what is
squarely
following from your
answering the issue.
lordship the other day? Perhaps that is the view, there is a constitution bench judgment. My lord, my learned friend is referring to a judgment regarding consideration of promotion on that day, right, 35. We are not on. When it comes to vested right, my lord, a vested right will accrue only when something has already been conferred to me by virtue of an unamended rule. And by amendment, you cannot say today you cannot hold the post. But something which is to happen tomorrow. In the meantime, if there is an amendment of the rule, perhaps that will not follow, because that is, my lord, constitution bench decision. I may just share with my friend, my lord, 1997, 6 SCC 623. It clearly says, my lord, a rule which operates in future so as to govern future rights to those already in service cannot be assailed on the ground of retroactivity as being violative of Article 14 and 16. But a rule which seeks to reverse from an anterior date a benefit which has been granted or availed, as for example, promotion, pay scale, can be assailed as being violative of Article 14 and 16 of the Constitution to the extent it operates.
Yes, yes. There is no dispute
That
with regard
the
to
view
this
which has
position.
lordship,
So
that
now-
is,
What's
My
your
lord,
answer?
my lord, let it come upon
Monday.
Friday
Monday.
or Monday, my lord.
Monday,
Monday, my lord, I'll have the instructions from the client.
Monday.
Other matters on Wednesday, Thursday, Friday.
Answer
Yes. Monday.
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 Now we were discussing something.
understand. Mr. Chaudhary, I Chaudhary, waiting for some matter?
Supplementary hearing matter. So there are several states involved. I should not be.
Oh, then sir.
That can be heard after.
After maybe after a week or 2 weeks. My lord,
First
that's
week
that's a case, my lord. I'm for the petitioner, my lord. I think, my lord, that's a case where we all need to put our hands together. Recently, my lord, there is a report, highest felling of tree in entire countries in Northeast. It is to the extent of 72%.
Yes.
The last week, my lord, in Times of India, we have read that news, my lord. So, my lord, everybody should put our hands together. If we are to get rid of this issue, we'll have to, some collective effort is required. It's not a question of putting blame on this or that, what had happened. Now, how to protect the environment, my lord.
Let it be sometime in the middle of June, my lord.
Yes, sir. And kindly see, my lord, tree cover loss in the country highest in Assam.
Why don't we have it on Environment Day,
Of course.
5th of June?
My lord,
That particular week, I'll have to be in Arunachal.
Lordship may kindly take it up on 19th.
19th, my lord, all of us are.
Let us see what happens on 5th of June. It's
Hey.
Environment Day, it's a symbolically. Can you not make some adjustments?
Your lordship is aware, madam. Some unavoidable circumstances in Arunachal.
The results I have, it was nothing. Assembly election. Don't worry, he'll be there.
I have been specially requested to be present there.
Because as I said the other day, my lord, khel abhi baki hai.
Otherwise, everyone seems to be in agreement.
The day of the
19th.
green bench day. Yes.
My lord, I come from outside your lordship.
Yeah, yeah.
My lord, I have item 56, my lord, let it come on Monday, your lord.
Monday,
Monday.
Monday
56.
hearing matter.
Hearing. I am nowadays coming from outside, my lord. That's why, my lord, I had a request, my lord. Item 56, my lord.
Okay, Monday.
Let it come on Monday, your lord.
Monday.
Item number 1.
Lord, I have instruction not to place this review. Lord.
Not to praise.
Not to place. Lord. In fact,
We were also thinking of that. What is the point in pressing?
correct, correct. Plus subsequent development is there, my lord. Already that has been taken care of.
Dismissed as not press. I'm concerned for the petitioner. Sorry, review petitioner on instruction as submitted that the petitioners does not want to press this petition, press this review petition, dismissed as not pressed.
No. Not.
Any IA? No, no IA, is no?
No, IA pending. No.
No, my lord. No.